Right.
There has been a complaint that the bench must speak up, that we will do our best. Please indicate when you cannot hear anything. Then we may proceed. You may proceed.
Good morning, Justices. Counsel for the respondents opposing respectfully ask that the lunch adjournment be shortened to half an hour, starting at about 1 p.m.
We did offer that.
We respectfully ask that, Milady.
And that is fine.
Thank you, Milady. We've also agreed to divide the day between us as follows. I will go until 2:30 p.m. My learned friend, Ms. Pillay, for the President, will then take 10 minutes. And my learned friend for the DA will go until the close of today's proceedings at 4 p.m.
Please follow the example of yesterday, stick to the time so agreed.
I will certainly do so, yes.
The other housekeeping, let's just start with yesterday, the amended notice of motion regarding the voting.
As my lady, as I was saying, it's mainly a formality because you would remember in the supplemental affidavit we had invited any parties who might want to object. Under Rule 28 and 9 were received. So we simply want to, and the amended notice is attached to the affidavit. So we just would want it to be formally admitted as the amended notice.
Any objection to that?
None from our side?
None from our side, my lady.
None from our side, my lady.
Also none from our side.
So amended.
Let's go, please.
Then there was the issue of the supplementary affidavit. Any objections there? After the affidavit.
Yes. My lady, it's not an objection as such, except just to point out what we said in our main argument, namely that one of the issues dealt with in that affidavit is the history of the matter and the appeals and so on. And we wish to point out that the omission of the word at this stage in respect of the Concord ruling may be misleading. We're not suggesting that it was deliberately made to be misleading, but I've already said yesterday what actually happened and why we didn't take the matter in. Let's go.
Any other comments?
None from our side.
The affidavit is then admitted. Then you must think that took care of all the house. Proceed.
Thank you.
Just before, did everybody receive the oral argument that was emailed? Yes.
Yes, we did, madam.
Then you may proceed.
Milady, members of the court, in his wide-ranging address yesterday, my learned friend for the applicant sometimes elided challenges to the new rules governing the process in the Assembly for motions for the removal of Chapter 9 office bearers, with challenges to the Speaker's decision that the notice of motion calling for the applicant's removal is in order. And at the end of his address, reading from paragraph 147 of the applicant's supplementary founding affidavit in volume 10, pages 969 to 972, my learned friend then repeated many of those points as grounds for the making of punitive and personal costs orders against the Speaker. In the circumstances, we consider it helpful to start by considering the relief sought by the applicant in her amended notice of motion, and then, when addressing the points made yesterday, to relate them to the orders she is asking this court to make. Starting then with the amended notice of motion. As the court knows, she seeks first an order declaring that the new rules made by the Assembly on the 3rd of December 2019, the new rules made on the 3rd of December 2019, declaring them to be unlawful, unconstitutional, invalid, and null and void. In the alternative, she seeks an order declaring that the rules do not operate with retrospective effect against her. In other words, in relation to her actions before they were adopted on the 3rd of December 2019. Third, she seeks an order reviewing and setting aside the decision of the Assembly to adopt the new rules. Fourth, and in the alternative to her third prayer, she seeks an order reviewing and setting aside the decision of the Speaker to approve the notice of motion dated 21 February 2020, calling for her removal. That, as the court will know, was the motion submitted by the Chief Whip of the Democratic Alliance, the DA, Ms. Mazzoni MP. The Speaker's decision was that it conformed to Rule 129R of the new rules. Fifth, she seeks an order suspending the invalidity of the new rules for a period of 6 months, within which the Assembly must effect the necessary amendments to bring them in line with the Constitution. She refers to this as structural relief. Sixth, she seeks such further alternative, just and equitable relief as the court may deem appropriate in terms of sections 38 and or 172 of the Constitution. And seventh, she seeks her costs of suit in these Part B proceedings, including punitive costs on the attorney and client scale against the Speaker and the Democratic Alliance, and or a contribution of 20% of such costs to be paid personally by the Speaker, de bonis propriis. We understood her counsel yesterday to have abandoned her claim for punitive costs against the DA. We shall deal with 9 topics today. First, we deal with the application. I needn't deal with that. 8 topics. First, to frame the rest of our submissions, we deal with section 194 of the Constitution, focusing on first the constitutional function it serves, namely as the ultimate mechanism for holding accountable incumbent Chapter 9 office bearers, and second, focusing on the respective roles and responsibilities of the Assembly and the President in impeachment proceedings under section 194 of the Constitution. Second, we outline what we submit are the key features of the new rules. Third, we deal with the threshold question of whether the Promotion of Administrative Justice Act 3 of 2000, PAJA, applies to the making, content, and implementation of the rules. We submit it does not, and consequently, the touchstone for the validity of the new rules and for reviewing their implementation is the principles of legality and rationality in the Constitutional. When dealing with these issues, we shall also respond to Advocate Mkhwebani's reliance on a right to fairness. Fifth, we deal in turn with each of the 12 grounds on which she seeks the orders invalidating the new rules, alternatively reviewing and setting aside the NA's decision on the 3rd of December 2019 to adopt them. Sixth, we deal with a request for an order suspending the declaration of invalidity for a period of 6 months. Seventh, we deal with the claim made in her counsel's heads of argument, but not foreshadowed in her notice of motion, for an order suspending the implementation of the new rules should she succeed with her claim for the invalidation of the rules. Eighth, we deal in turn with each of the 9 grounds on which she seeks the order reviewing and setting aside the Speaker's decision of the 26th of February 2020, that Ms. Mazzoni's motion of the 21st of that month is in order. And lastly, we deal with her prayer for personal and punitive costs against the Speaker. Dealing first then with section 194 of the Constitution. In our heads of argument at paragraphs 108 to 118, we discuss section 194 of the Constitution, including the constitutional function of impeachment proceedings and the respective roles and responsibilities of the National Assembly and the President in section 194 impeachment proceedings. It's perhaps as well to consider the terms of section 194 and its equivalent in relation to the President, section 89, because of the reliance that we shall be placing on a decision by the Constitutional Court interpreting and applying the latter. As the Court knows, section 194, which is headed removal from office, provides in subsection 1 that the Public Protector, the Auditor General, or a member of a commission established by this chapter may be removed from office only A, on the ground of misconduct, incapacity, or incompetence, B, a finding to that effect by a committee of the National Assembly, and C, the adoption by the Assembly of a resolution calling for that person's removal from office. Subsection 2 provides that a resolution of the Assembly concerning the removal from office of the Public Protector or the Auditor General must be adopted with the supporting vote of at least 2/3 of the members of the Assembly. There are currently 400 of them. And secondly, such a resolution in relation to a member of a commission established by Chapter 9 must be adopted with the supporting vote of a majority of the members of the Assembly. Subsection 3 provides that the President may suspend a person from office at any time after the start of the proceedings of a committee of the Assembly for the removal of that person, and also and further that the President must remove a person from office upon the adoption by the Assembly of the resolution calling for that person's removal. We submit that section 194 is similar to section 89(1) of the Constitution, which provides as follows in relation to the removal of the President. The National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the President from office only on the grounds of A, serious violation of the Constitution or the law, B, serious misconduct, or C, inability to perform the functions of office. The similarities between the two provisions are the following. Both confer the power of removal on the Assembly. Both require the Assembly to exercise that power by means of a resolution, and both contain grounds of removal. The main differences between the two provisions are the following. Firstly, the grounds of removal in section 194(1)(a) include incompetence, whereas, and that sentence should be completed, section 89(1) does not permit the President's removal on that ground. I apologize for the error from that paragraph. The equivalent in section 194(1)(a) to the grounds of removal in sections 89(1)(a) and (b), in other words, serious violation of the Constitution or the law, or serious misconduct, is misconduct. And the equivalent in section 194(a) to the ground of removal in section 89(1)(c), which is inability to perform the functions of office, is incapacity. Another difference is that section 89(1) has a single stage process. That is simply a resolution by the Assembly removing the President. Section 194(1) and 2 contains a 3-stage process, requiring first a finding by an Assembly committee that a ground of removal is present. Second, a resolution by the Assembly that the Chapter 9 office bearer be removed from office. And third, the removal of the office bearer by the President. The latter is a formal act because the President must remove the office bearer upon the adoption of the resolution by the Assembly. And the last difference is that Section 1942 imposes a lower voting threshold for the removal of most Chapter 9 office bearers, a majority of the 400 members of the NA, except for the Public Protector and the Auditor General, where, like the President, a 2/3 majority is required. Now, as the court will have seen, our discussion of Section 194 is based largely on three authorities. The first is United Democratic Movement versus the Speaker, National Assembly, 2017 5 SA 300 Constitutional Court. We shall refer to it as UDM, and it's in the bundle at page 685. May I just pause here to say that unless I take the court to the bundle, I won't give the bundle reference every time. It's there for the court's convenience when considering its judgment. Now, this was a unanimous judgment of the Constitutional Court, in which it was decided that the Speaker has the power to rule that voting on a motion of no confidence in the President in terms of Section 102(2) of the Constitution must be conducted by secret ballot. We refer the court in particular to paragraphs 9 to 10, 39 to 47, 57 to 59, 62 to 64, 68 to 69, and 82 to 88 of the judgment of the Chief Justice, Justice Mogoeng. The second judgment is Economic Freedom Fighters and Others versus the Speaker of the National Assembly and another. 2018 Volume 2 SA 571 Constitutional Court, EFF Impeachment. In this case, which is undoubtedly the most important for purposes of determination of the matter before the court today, the majority of the Constitutional Court held that the Assembly was obliged to adopt rules defining the grounds on which the President may be removed from office in terms of sections 89(1) and 2, and 89(1), and secondly, regulating the process in the Assembly for the President's impeachment in terms of that section. We refer the court in particular to the following paragraphs of the judgment of Jafta J for the majority. Paragraphs 100 to 131, 133 to 136, 138 to 139, 164, and then particularly 170 to 182, the first set of what we submit are the key paragraphs, and 187 to 196, the second set of key paragraphs. And the bundle reference there is 213. May I take the court to page 213, because I wish to make certain submissions pursuant to or following from what the Constitutional Court said in that regard. May I proceed, Malay?
You will. You might proceed.
Thank you. Starting at paragraph 176, His Lordship said, "The power to remove the President from office is available to the Assembly only if one of the listed grounds is established. One of those grounds is a serious violation of the constitutional or the ordinary law. What qualifies this ground is the word serious. The second ground is serious misconduct, and the third is inability to perform the function of office. None of these grounds is defined in the Constitution. Now, I just wish to pause there to make the following point. As the court knows, those grounds are more elaborate than the grounds in section 1941. So, for instance, one sees the first two being a serious violation of the Constitution or the ordinary law and serious misconduct. The correlative in 194 is simply misconduct. But as we shall see, despite the elaboration in the Constitution, the adjectives used, and the focus of them, violations of the Constitution or the law, etc., the court went on to hold that definition was necessary. And the issue is definition by whom and in what way. And the answer to that is given in 177. It is evident that the drafters left the details relating to these grounds to the Assembly to spell out. But the drafters could not have contemplated that members of the Assembly would individually have to determine what constitutes a serious violation of the law or the Constitution, and conduct on the part of the President, which in the first place amounts to misconduct, and whether in the second place such conduct may be characterized as serious misconduct. If this were to be the position, then we would end up with divergent views on what is a serious violation of the Constitution or the law, and what amounts to serious misconduct envisaged in this section. And since the determination of these matters falls within the exclusive jurisdiction of the Assembly, it and it alone is entitled to determine them. This means that there must be an institutional predetermination of what a serious violation of the Constitution or the law is. The same must apply to serious misconduct and the inability to perform the functions of office. The acting speaker describes the first two grounds as exhibiting wrongdoing on the part of the presidents. I could not agree more. This is evident from the language of section 89(2), which stipulates that a president removed from office on any of these two grounds may lose benefits. Once more, it is left to the Assembly to determine the circumstances under which the president removed from office on one of those grounds may forfeit benefits. For the impeachment process to commence, the Assembly must have determined that one of the listed grounds exists. This is so because those grounds constitute conditions for the president's removal. A removal of the president where none of these grounds is established would not be a removal contemplated in section 89(1). Equally, a process for removal of the president where none of those grounds exists would amount to a process not authorized by the section. Therefore, now his lordship turns to the process. Any process for removing the president from office must be preceded by a preliminary inquiry, during which the Assembly determines that a listed ground exists. The form which this preliminary inquiry may take depends entirely upon the Assembly. It may be an investigation or some other form of inquiry. It is also up to the Assembly to decide whether the President must be afforded a hearing at the preliminary stage. My lady, I pause simply to impress on the court the obvious parallels between the descriptions of what is required here and what is clearly required in relation to section 194, but also to emphasize that our Constitution, as interpreted and applied by the Constitutional Court, has said that these matters are matters for the Assembly to decide, including whether the President be afforded a hearing at the preliminary stage. I continue. At 181, since the power to remove is institutional, the Assembly must decide and facilitate the initiation of the preliminary stage. It may well be that each member of the Assembly has a right to initiate the preliminary process. Even so, the Assembly must facilitate steps to be taken in this regard and a process to be followed, not only at a preliminary stage, but also at the stage of the actual impeachment, up to the final stage of voting on whether the President should be removed from office, so as to determine whether the removal is supported by the necessary 2/3 majority. And then the first section 182. Without rules defining the entire process, it is impossible to implement section 89. And may I then ask the court to turn to paragraph 187 at page 215. In opposing the claim that the Assembly failed to put in place mechanisms for deciding impeachment proceedings, the acting Speaker also called in aid Rule 253, which governs the establishment of ad hoc committees. He said a member of the Assembly may request that impeachment matter be referred to an ad hoc committee established in terms of the rules. This rule, he continued, requires the Assembly to specify the task assigned to the committee, which may include conducting an inquiry or investigation and reporting or recommending to the Assembly on steps to be taken pursuant to its findings. And then down to 189. On this approach, it's the initiator of the process who determines whether the President has committed a serious misconduct or a serious violation of the Constitution or the law. If the initiator holds that opinion, he or she may request that an ad hoc committee be established to investigate and recommend to the Assembly that the President be removed from office. This process lacks a sifting mechanism which would determine whether there is a case for the President to answer. But over and above that, the ad hoc committee process doesn't have a set procedure for the committee to follow in carrying out its task. More importantly, in terms of Rule 255, a question before an ad hoc committee is decided by agreement among the majority of the members present, unless the resolution establishing the committee provides otherwise. And I do not intend reading the rest, just simply to take the court to the concluding statement in paragraph 196, which is this. In the result, I conclude that section 89(1) implicitly imposes an obligation on the Assembly to make rules specially tailored for an impeachment process contemplated in that section. And I hold that the Assembly has, in breach of section 89(1), failed to make rules regulating the impeachment process envisaged in that section. We submit the I'm returning to the note. We submit the similarities between
Mr. Grantable,
My
can
lad-
you hear?
Yes, I can hear you.
Okay, please proceed.
Thank you. We submit the similarities between section 89(1) and 194 are such that the Assembly is similarly obliged to adopt rules, firstly defining the grounds on which a Chapter 9 office bearer may be removed from office in terms of section 1941A, and secondly, regulating the process in the Assembly for the impeachment in terms of section 194. The third authority to which we direct the court's attention is Institute for Accountability in Southern Africa versus the Public Protector and Others, 2020, Volume 2, All South Africa, 469, Gauteng, Pretoria. That was an application for orders by a court declaring the present applicant unfit to hold the office of Public Protector on grounds which bear a close resemblance to the charges in Ms. Mazzoni's motion before the NA. The application was dismissed. As regards the Institute's grounds, which were based on the findings critical of Advocate Mkhwebane in the litigation listed in the charges in Ms. Mazzoni's motion, we refer the court to paragraphs 4 to 18 of His Lordship Mr. Justice Coppin's judgment. As regards the significance of those findings, we refer the court to paragraph 31 of the judgment, and as regards his reasons for dismissing the application, chief among them being that granting the relief sought would impinge upon the Assembly's power and duty to deal with Ms. Mazzoni's motion, and consequently violate the separation of powers, we refer to paragraphs 34 to 53 of Coppin J's judgment. And having regard to these authorities, we emphasize the following 8 points relating to Section 194 of the Constitution. First, all Chapter 9 institutions, including the Public Protector, are accountable to the Assembly. Section 1815 of the Constitution provides the Chapter 9 institutions are accountable to the Assembly and must report to the Assembly on their activities and the performance of their functions at least once a year. Second, Section 194 of the Constitution, which empowers the Assembly to decide to remove Chapter 9 office bearers from office, is what His Lordship the Chief Justice in the UDM case of paragraph 10 called the ultimate accountability ensuring mechanism for all office bearers of Chapter 9 institutions. That was a statement made with reference to Section 89(1) of the Constitution, the presidential equivalent to Section 194. Third, Section 55(2)(b)(2) of the Constitution obliges the Assembly to provide for mechanisms to maintain oversight over, amongst others, all organs of state, the Public Protector and the other Chapter 9 institutions being organs of state. Fourth, the rules of the Assembly are such a mechanism. Section 59(1)(b) empowers the Assembly to make rules concerning its business. Fifth, the Assembly is obliged to adopt rules which give meaning to the grounds of misconduct, incapacity, and incompetence set out in Section 1941. That's the essential holding in paras 176 to 178 of the case that I've just referred the court to. We point out that this, as I mentioned earlier, that the Constitutional Court made this finding in relation to Section 89(1), even though it describes the grounds for impeachment of the President in more detail than Section 1941A does in relation to the Chapter 9 office bearers. The sixth principle is the Assembly is obliged to adopt rules which regulate the entire process in the Assembly, including but not limited to the following. Firstly, describing the manner in which the impeachment process must be initiated. Secondly, creating a sifting mechanism to determine whether the Chapter 9 office bearer has a case to answer. Thirdly, regulating the proceedings in the Assembly Committee, which must consider and decide whether a Chapter 9 office bearer is incapable or incompetent or has misconducted themselves. The seventh principle is that if at the end of the impeachment process in the Assembly decides by the majority prescribed by Section 1942, 2/3 of its members in the case of the Public Protector and the Auditor General, that the office bearer must be removed, Section 1943 obliges the President to remove that person from office. The point we are seeking to make there is that it is an Assembly matter from beginning to end, with a formal obligation to remove at the conclusion of the process. And consequently, the eighth principle is thank you. Consequently, the eighth principle is this. The principle of the separation of powers requires that this court respect the fact that the power to determine the fitness of a person to continue to hold the office of the Public Protector has been assigned by the Constitution to the Assembly and the President. This means that this court should not interfere in the process of the Assembly unless interference is necessary to ensure that the Assembly acts within the law and fulfills its constitutional obligations. And I would add in that regard the following. This court is also bound to respect the fact that the power to make these rules, to define the terms in the Constitution and to determine the process is one vested in the Assembly by the Constitution, It is, to use the words of Jafta J for the majority of the court, something for the Assembly and the Assembly alone. And we deal later, albeit briefly, with the implications of this principle for the application for judicial review of the Speaker's decision to accept Ms. Mazzoni's motion is in order. That then brings me to the key features of the new rules. As the court knows, on the 3rd of December, the Assembly unanimously adopted the rules. That is the Speaker's evidence, and it is not contradicted. The new rules are part 4 of Chapter 7 of the National Assembly Rules. They comprise 6 definitions and rules 129R to 129AF, and they were accompanied by a consequential amendment to National Assembly Rule 88. They are to be found in a report of the Assembly's Rules Committee, a copy of which is Annexure PPFA 7 in Volume 2 at pages 142 to 147, and it's sections D and E of the report. And for a somewhat clearer copy, see Annexure TRM 37, Volume 5, pages 475 to 480. I have taken my copy of the latter out of the file, and I would be grateful if the court would do the same, because I'm going to be referring on and off to the new rules. So unless the court has the new rules extracted, I'd be grateful if either that would be turned open, or if those pages, it's volume 5, pages 475 to 480, are readily to hand.
You may proceed.
Thank you. In our heads of argument at paragraphs 119 to 144, following an equivalent section in the Speaker's main answering affidavit, we describe the 17 steps for the impeachment process under Section 194 of the Constitution and the new rules. We shan't repeat the details of that description. Instead, we shall limit our oral submissions on this aspect to emphasizing 2 key features of the new rules. The first key feature is that, in line with the judgment of the majority of not this court, it's be the Constitutional Court in EFF impeachment at paras 176 to 178, the new rules define the grounds of misconduct, incapacity, and incompetence as set out in Section 1941. Later, I shall come to the applicant's challenges to those definitions. The second key feature of the new rules that in line with EFF impeachment paras 180 to 182 and 189 to 190, the rules regulate the entire process in the Assembly, including the following. Firstly, the manner in which the impeachment process must be initiated, namely by a notice of a substantive motion containing a clearly formulated and substantiated charge or charges and attaching all of the evidence relied upon. Secondly, 2 sifting mechanisms to determine whether the Chapter 9 office bearer has a case to answer, namely an initial assessment by the Speaker of whether the motion is compliant with the criteria in Rule 129R, one sees that in Rule 129S, and a subsequent assessment by a 3-person independent panel of whether there is prima facie evidence to show that the incumbent has committed the misconduct or is incompetent or incapacitated for the reasons alleged in the motion. Thirdly,
Yesterday I asked as the OFU whether the 3-person independent panel
is in line with the EFF impeachment judgment, where Justice Chapter repeatedly said that the process belongs to the National Assembly. That is, it is the National Assembly that must control the process to its end. Now, the three panel is not part of the National Assembly. It's an independent body. Will you say that the process is still in the hands of the National Assembly, especially where this body must make a prima facie finding that there is an impeachable offense committed by Chapter 9 pay?
The answer to that is yes, my lord, and thank you for the question. The reason is the following. The panel is an advisory body. It makes recommendations it reports and makes recommendations to the Assembly, and the third principle in 26.3 of my note then applies. After
let's say recommendations. I understand it to mean that the National Assembly may get advice from experts, isn't it?
It is simply an advisory body. I'm having a little difficulty hearing you, my lord, but if you're saying you understand it to be that the Assembly is entitled to receive advice, that is my respectful submission. The point is that Section 129Z sub 2 requires the Assembly, after receipt of the recommendations, itself to decide whether an inquiry in terms of 194 should be proceeded with.
I don't have a difficulty with the National Assembly itself having to decide. I have difficulty with it being advised as to what constitutes prima facie, which is the function of the National Assembly itself to do that, isn't it? But here,
I respectfully,
that body that must make that finding and then advise the National Assembly.
my lord, I suspect that your difficulty will evaporate if, upon closer consideration of the relevant rules, Rule 129X and Rule 129Z, one sees the following. The panel is appointed to conduct this inquiry and to report to the Assembly and make a recommendation on the assessment that it has to undertake, namely whether there is prima facie evidence to show that the incumbent has committed the misconduct or is incompetent or is incapacitated for the reasons given in the motion. The Assembly, however, must consider those recommendations and decide for itself whether or not a Section 194 inquiry be proceeded with. It is not bound by anything that the panel says. The panel may well advise it that may I finish? The panel may well advise it that there is no prima facie evidence, but the majority of the Assembly may think otherwise and take the matter to the next stage. It is not a condition precedent for any such decision. Equally, the panel may advise it that there is prima facie evidence, and the Assembly may decide not to take the matter to the next stage. And the last point that I wish to make in this regard is the following, is of course Section 194(1)(b) is not applicable at the preliminary stage that we are speaking about, the screening stage. It applies to the proceedings of the Section 194 committee, which is established only if the Assembly as a whole decides that there shall be such a committee. So there is no trenching in this screening process on the Assembly's function.
What is then the purpose of having that panel included in the rules of the National Assembly if it has no function at all? from what you say, the National Assembly is free to decide whether to accept that there is an impeachable offense or not. So what is the purpose of having an independent body interfering with the process that is exclusively the National Assembly's process?
The reason for that is the following. The people to be appointed to that body are and must be independent. So they are people who are certainly politically independent would be an essential requirement. Secondly, they must possess the necessary legal and other competencies and experience to conduct the assessment required of them by Section 1, Rule 129X. I'm referring to Rule 129V1. So the reason for doing so is that to provide a sifting mechanism, one where before the Assembly goes to a 194 committee, a body of independent experts, people with the necessary legal and other competencies, assess the evidence put up by the person who's promoted the motion to advise essentially whether there is prima facie evidence to show that the incumbent has committed the misconduct, etc., alleged. It is in short, it is to allow the Assembly to make an informed decision about whether or not to proceed to the serious and important stage of holding such a committee.
The Constitution entrusts the Assembly with such an important task in terms of Section 194, because the Constitution believes that the Assembly possesses of the necessary skills and expertise to determine whether there has been an infringement of the duties of a public protector. Now, why should that very same body that is entrusted with such serious powers decide to delegate it to a body that is not answerable in terms of the Constitution?
The answer to that is multifold. The first is Jafta Jay's judgment requires that there be sifting mechanisms, and what has been done here is a careful sifting mechanism, a double sifting mechanism. First, the Speaker's assessment of the motion. May I just add, in direct response to the point made, that of course the Speaker herself is not the National Assembly, and I will emphasize again that the details of these mechanisms is something which the Constitutional Court is something left to the Assembly. The second point is that the decision to establish a committee taken under Section 194, or in relation to 194, just to establish the committee, is one which has to be carefully taken. And so what the Assembly has decided is that they will take and receive independent expert advice before establishing a committee. Why is it so important? It's so important because Section 1943A provides that the President may suspend a person from office at any time after the start of the proceedings of the committee. That is why care has been taken by the Assembly to ensure that it is properly advised before it takes a decision in terms of Rule 129V that a committee be established. If the court were to hold it against the committee, being careful, if the court were to hold against the Assembly that it has devised a rule to ensure that it acts carefully and in an informed manner, that with respect would be incorrect. It is the Assembly's prerogative to decide whether it's going to take advice. It has decided that in every case of this kind, it will take the advice of an independent panel before deciding to establish such a committee.
I have no difficulty with that. difficulty with a rule that says that important function is now given to a body outside the National Assembly. We can accept that the difference between the EFF judgment and the present matter is that in the EFF impeachment judgment, there were no rules. And that is why Jafta was saying the National Assembly must make the rules. In this case, the rules are there. We have to look at whether these rules are in accordance with the Constitution. Are they in accordance with what is required of the National Assembly when it embarks on the process of impeaching? Chapter 9, head of a Chapter 9 institution.
With respect, there were rules in place in EFF impeachment, but there were not special rules for an impeachment process.
Exactly.
Now has special rules for an impeachment process, and the fundamental, with respect, misconception underlying the point being put to me is that there is somehow a delegation by the Assembly to this outside body of decision-making power. There isn't. It is the one which must decide whether the matter moves to Section 194.
On that board.
And it is simply provided, the Assembly has simply provided that it will receive independent and expert advice before taking such a momentous decision, one which will expose a Chapter 9 office bearer to the prospect of suspension. That, with respect, is something which cannot be held against the Assembly. It doesn't involve passing the buck or a failure to exercise its authority. It is simply ensuring that it is best equipped to take a proper decision.
Okay.
I've already mentioned that after the receipt of the recommendations, an initial decision has to be taken by the Assembly as to whether an inquiry in terms of Section 194 should be proceeded with. And then there is the conduct of that inquiry. The committee is a specially appointed one. We shall call it a Section 194 committee. And it has to make a finding, the finding referred to in Section 1941B, as to whether the incumbent has committed the misconduct or is incompetent or incapacitated for the reasons alleged in the motion. And after receiving that report and recommendations, and if the committee recommends that the incumbent be removed from the office, voting on that question. Now, it's obviously important to bear in mind that if there is no finding adverse to the incumbent under Section 1941B, then there can be no vote for the removal of that person. The rules recognize that. There will only ever be a vote on a removal motion if the committee has recommended that the incumbent be removed from office, in other words, has made a finding adverse to them. I emphasize that for the following reason. There are allegations on the other side that these rules are arbitrary, irrational, and so on. I respectfully submit that even a cursory, not even a close reading of the 17 steps required by this process shows that this is a carefully constructed process aimed at ensuring that the Assembly can exercise this very important oversight, accountability function in a proper manner, in a manner consonant with our Constitution, bearing in mind, obviously, that many of these institutions are people who will, in the ordinary course of their work, rub people in power up the wrong way. This system is designed to ensure that someone is not removed unless, in the Assembly's assessment, and the supermajority in the case of the public protector, there is indeed cause for that to happen. And as the court will be aware, it's not sufficient for there simply to be a finding, say, of misconduct. 2/3 of the Assembly must, so the Constitution says, decide essentially for political reasons, because that is a political body at the end of the day, that the removal is justified on account of the misconduct which is found. So there's an added element. There will be a political debate in a political body. The preeminent political body in our country has been entrusted with this function. That then brings me to the touchstone for the validity of the new rules and for the challenges to their implementation. And we deal with this because, with respect, our learned friend is, in many of the points made, has been applying the wrong standard. The threshold question is whether PAJA applies. Why is that a threshold question? Because PAJA, as the court well knows, which applies to administrative action, requires, amongst other things, that administrative action which materially and adversely affects the rights or legitimate expectations of any person must be procedurally fair, and that in order to give a right to effect to that right, someone who takes a decision of that kind must give them adequate notice of the nature and purpose of the proposed administrative action and a reasonable opportunity to make representations. And much has been said to you and in the papers requiring notice and an opportunity to comment or make representations at each and every stage of the proceedings. And ultimately, what we will be submitting is two things. The first is that PAJA does not apply to this process. And secondly, the applicant's reliance on a general right to fairness is also misplaced. So the issues are, does PAJA apply to the making, content, and particularly the implementation of the rules? And secondly, what is the touchstone for the validity of the rules? We submit it's the constitutional principles of legality and rationality. So, dealing first with PAJA, our first point is that the right to lawful, reasonable, and procedurally fair administrative action in Section 33(1) of the Constitution and the right to written reasons in Section 33(2) do not find direct application in proceedings for judicial review of administrative action. The reason is that following the enactment of PAJA in terms of Section 33(3) to give effect to those rights, all proceedings for judicial review must be brought in terms of PAJA. That was the central holding, or one of the central holdings, the famous Batterstar case, 2004, 4 SA 490, Constitutional Court at paragraphs 21 to 26. Now, we submit for three reasons the provisions of PAJA, including its provisions regarding procedurally fair administrative action in Sections 3 and 4, and the provisions regulating the right to written reasons for administrative action in Section 5, and the grounds for judicial review of administrative action in Section 7(1), including unreasonableness, do not apply to the making or the implementation of the new rules by the Assembly. First, the definitions of administrative action and decision in PAJA make clear that it applies to decisions of an administrative action. In the words of the SCA in Gray's Marine Haute Bay, 2005, 6 SA 313 SCA at paragraph 24, the conduct of the bureaucracy, whoever the bureaucratic functionary might be, in carrying out the daily functions of the state, which necessarily involves the application of policy, usually after its translation into law with direct and immediate consequences for individuals or groups of individuals, decisions of an administrative nature. Secondly, neither the making nor the implementation of these rules by the Assembly entails or will entail the bureaucratic carrying out of the daily functions of the state. That is, to put it at its lowest, it's a most unusual and extraordinarily serious process in the Assembly. Thirdly, the making of the rules entailed the exercise of the legislative function of parliaments, which is expressly excluded from the definition of PAJA administrative action by paragraph DD of that definition. That then brings us to Advocate Mbabani's reliance on fairness. We submit that the touchstone for the validity of the rules is the constitutional principle of legality, which includes, I'd add in the words non-arbitrariness and substantive rationality. Non-arbitrariness and substantive rationality, and that's on the strength of the Minister of Justice and Constitutional Development, and another versus the South African Restructuring and Insolvency Practitioners Association and others. 2018, Volume 5, SA 349, Constitutional Court. If the court would note there, paragraphs 54 and 55, and I'm going to go there briefly. And the second element is procedural rationality. So there's a substantive component, non-arbitrariness and substantive rationality, and procedural rationality. Now, before describing procedural rationality, it's as well, because of some of the grounds of challenge raised, just to remind the court of what the Constitutional Court said in paragraphs 54 and 55 of the SA Insolvency, Restructuring and Insolvency Practitioners Association case. It's in the bundle at page 429, but with your permission, I'll just read the passages. They're not very long. Halfway through paragraph 54, His Lordship, Mr. Jafta J, speaking again for the majority, said, every action or decision taken in the exercise of public power must be supported by plausible reasons. These reasons must show that power was exercised to achieve a legitimate governmental purpose for which that specific power was conferred. It is those reasons which may insulate the exercise of power on the ground of arbitrariness. Paragraph 55. While there may be an overlap between arbitrariness and rationality, these are separate concepts against which the exercise of public power is tested. Arbitrariness is established by the absence of reasons or reasons which do not justify the action taken. Rationality does not seek to justification of the action, but a different issue. Rationality seeks to determine the link between the purpose and the means chosen to achieve the purpose. It is a standard lower than arbitrariness. All that is required for rationality to be satisfied is the connection between the means and the purpose. Put differently, the means chosen to achieve a particular purpose must reasonably be capable of accomplishing the purpose. They need not be the best means or the only means through which the purpose may be attained. Turning then to procedural rationality, it is a concept which is developed in three judgments in particular of the Constitutional Court. The first is Albert and the Centre for the Study of Violence and Reconciliation, 2010, 3 SA 293, Constitutional Court at paragraphs 49 to 51. The second is DA and the President, 2013, 1 SA 248 at para 39, and the third is the Law Society and Others and the President, 2019, 3 SA 30, Constitutional Court at para 61 to 65. Generally speaking, what it entails is looking at the process as a whole and determining whether the steps in the process are rationally related to the ends sought to be achieved, and if not, whether the absence of a connection between a particular step, which is part of the means, is so unrelated to the end as to taint the whole process with irrationality. We submit that there is no free-floating standard of fairness that applies to decisions or actions that are not administrative action as contemplated by PAJA. We do, however, point out that the new rules make specific provision for procedural fairness in the Section 194B committee. Rules 129 AD 2 and 3 provide the committee must ensure the inquiry is conducted in a reasonable and procedurally fair manner and must afford the officeholder the right to be heard in his or her defence. That then brings me to Advocate Mkhwebani's challenges to the validity of the rules. May I say that I prepared this note with reference to the heads of argument, and one or two of the points raised in the heads on the other side were not persisted with. When I get to a point of that kind, I shall identify it and not address oral argument on the point, as none was done yesterday. So there are 12 challenges then to the validity.
Just bear in mind that although the applicant not raised every reason in oral argument, they made it clear that they're not abandoning. That's the way I.
Thank you very much. May I say that the way in which we intend dealing with that then is in relation to those matters which were not canvassed orally. We stand by what is written here, but I shan't detain the court with oral argument on those aspects, and I will identify each such matter. There aren't many of them as and when that we get to them. The first point is the contention that it was incumbent on the Assembly to consult the Chapter 9 office bearers, and specifically Advocate Mkhwebane, before making the rules. Two reasons are given. The first is the allegation that the Assembly acts as the employer of the Public Protector and the other Chapter 9 office bearers, and the new rules change their conditions of employment. In this regard, she invokes the rule of law, sections 7 sub 2 and 23 of the Constitution, that's the right to fair labour practice, and as support for this proposition, that their conditions of employment cannot be altered without consulting them. The second point raised in this regard is that it's contended Section 57(1)(b) of the Constitution requires the NA to make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. Now, that particular contention, the 57(1)(b) contention, was not pressed in argument yesterday. We deal with it in the noted paragraphs 44 to 49. It is also something which comes up in the DIA case, and I shall consequently not address oral argument to you on it today. I shall focus on the first one, namely her contentions that the NA is her employer and has changed the conditions of her employment. As the court knows, we deal with that in our main heads at paras 173 to 175. The main difficulty with this contention is the following. The Public Protector is not employed by anyone, be it the Assembly or anyone else. The incumbent Public Protector, like other Chapter 9 office bearers, is the holder of an office created by Chapter 9 of the Constitution to strengthen constitutional democracy in our country. Hence, Section 181(2) of the Constitution makes it clear that the public employer is independent and subject only to the Constitution and the law. The position of the Public Protector in this regard, I might add, is not dissimilar to the position of the members of this court. You two are not employed by anyone. With respect, you hold important offices created by the relevant chapter of the Constitution. Returning to the Public Protector, her relationship with the Assembly is a special one. It's founded in the Constitution, which assigns three specific functions to the Assembly in relation to the Public Protector. Firstly, the Public Protector is appointed by the President on the recommendation of the Assembly in terms of Section 193, 4 and 5 of the Constitution. Secondly, the Public Protector is accountable to the Assembly and must report on her activities and performance of her functions to the Assembly at least once a year in terms of Section 181, 5 of the Constitution. And thirdly, the Public Protector must be removed from office by the President upon the adoption by the Assembly of a resolution calling for her removal as envisaged in 194 of the Constitution. None of the elementary requirements for an employment relationship between the Public Protector and the Assembly are present. In particular, unlike an employee, the Public Protector does not work for the Assembly or assist the Assembly in carrying out or conducting its business. And there's no contract between the Assembly and the Public Protector, let alone an employment contract. Finally, on this issue, and even assuming that the Chapter 9 office bearers are employed by someone, the definitions of misconduct, incompetence, and incapacity in the new rules do not alter their conditions of employment. They were adopted to give meaning to the grounds of misconduct, incapacity, and incompetence set out in Section 1941, in line with the CSC's holding in EFF impeachment. That then takes me to page 18 of my note, paragraph 50. Her second challenge to the new rules. That is that they impermissibly change the thresholds for impeachment in Section 194 of the Constitution. We deal with this issue in our main heads in paragraphs 193.3 and 198, and in our supplementary heads at paragraphs 27 to 30. For three main reasons, we submit this contention is unsound. First, while the applicant is right that Section 1941A of the Constitution says simply that the Public Protector, Auditor General, or a member of a Chapter 9 Commission may be removed from office only on the grounds of misconduct, incapacity, or incompetence. In EFF impeachment, dealing with the comparable Section 89(1), the Constitutional Court held that the Assembly is obliged to adopt rules which give meaning to the ground of impeachment. In other words, the drafters of the Constitution left the details relating to these grounds to the Assembly to spell out in its rules regulating the impeachment process. Secondly, in our submission, it is permissible for the Assembly, when drafting the grounds on which Chapter 9 office bearers may be removed from office, to qualify the terms misconduct, incompetence, and incapacity. In fact, I would go so far as to say that will invariably happen when the Assembly carries out its duty, its definitional duty. In so doing, we submit the Assembly may permissibly make impeachment more difficult than would otherwise be the case. The Assembly's defining the grounds of impeachment in this way doesn't involve an impermissible amendment to the Constitution. The reason is that in EFF impeachment, the CC didn't merely authorize the Assembly to adopt rules defining the grounds of impeachment, it made it obligatory for the Assembly to do so. And as regards the proposition about making it more difficult, the basic point is this. This is the ultimate accountability mechanism which inheres in the Assembly. It's for the Assembly to decide, firstly, when defining the circumstances in which an office bearer may be removed, and secondly, when taking the ultimate, what I call the political decision in the Assembly itself, even if a finding is made, whether someone should be removed. In other words, to exercise what my learned friend called the, I think it was, he referred to a career death sentence or something to that effect. I mean, that's very dramatic. But it is ultimately for the Assembly to decide what will constitute misconduct, etc., both in general as an institutional predetermination, in the specific instance in the 1 Section 9(4) committee, and then to decide whether, if such a finding is made, that the person must be removed from office. The third point that we wish to make relates to the details of these definitions, and if I could ask the court just to get the relevant parts of the rules handy for that. And before dealing with the details, I just ask your ladyship, I'm very happy to continue work until 1 o'clock or at any other convenient time for an adjournment.
We make that way, we make up for the time starting late. So
Thank you. Thank you. So these definitions, I'd like to focus first on the definitions of incompetence and misconduct. We submit they impose higher thresholds for impeachment than the ordinary meaning of those words would otherwise impose. And we submit that the definition of incapacity doesn't change the threshold either way. Misconduct is defined to mean the intentional or gross negligent failure to meet the standard of behaviour or conduct expected of a holder of public office. That, in the Assembly's estimation, is the circumstance on which, or the circumstances in which it will hold, or a Chapter 9 office bearer is liable to be held ultimately accountable by it. That's not an impermissible amendment of the Constitution. It's an exercise of its power and authority to define. It's done so in a way which raises the threshold. The definition of incompetence.
We heard the argument yesterday, exactly the opposite, that the Assembly is not allowed. What you said.
Yes, the answer to that is very simply in paragraph 177. It is this is of the EFF impeachment. It's evident that the drafters left the details relating to these grounds to the Assembly to spell out. And at the end of the determination of these matters falls within the exclusive jurisdiction of the Assembly. It and it alone is entitled to determine them. This means there must be an institutional predetermination of what a serious violation of the Constitution or the law is, etc. So what we have here is an institutional predetermination of what misconduct is. The Assembly says to Chapter 9 office bearers, misconduct is the intentional or gross negligent failure to meet the standard of behaviour or conduct expected by a holder of public office. That's a legitimate exercise of its power and duty to define these terms institutionally in advance of any case being considered by it. The second is incompetence. Now, this is a non-exhaustive definition. It's got the word includes. It includes the following exacting requirements in relation to the holder of a public office, namely a demonstrated and sustained lack of either the knowledge to carry out, and secondly, the ability or skill to perform his or her duties efficiently. Now, the thing about a definition of that kind is that in relation to the matters that it covers, a lack of knowledge, lack of ability, lack of skill, it covers the field. In other words, it says, if you want to say that someone is incompetent because they lack the knowledge, ability, or skill, then you must have a look at these. You must have a look at how it's defined here. And it must be demonstrated and sustained. And it must have the consequence that the person cannot carry out their duties efficiently. So it's exhaustive of virtually every conceivable circumstance in which someone could be plausibly said to be removable for incompetence. Hence our submission is that it too raises the bar or the threshold higher than the ordinary meaning of the words would otherwise indicate. Turning to the definition of incapacity, we heard quite a lot about that yesterday. As the court is undoubtedly aware, the applicant is not charged with incapacity, but be that as it may, she's brought this challenge generally. The focus was particularly on the inclusion of a temporary condition in paragraph A. Now, although paragraph A, which reads a permanent or temporary condition that impairs the holder of a public officer's ability to perform his or her work, includes temporary incapacity, we submit that does not alter the threshold. The reason is the word temporary relates to the cause of the incapacity and not the incapacity itself. Now, put differently, in cases of both temporary and permanent alleged incapacity, the question for decision, in other words, the requirement, remains the same, namely whether the condition results in the impairment of the Chapter 9 office bearer's ability to perform his or her work. We give the following example of a public protector. As the court knows, they are appointed for a non-renewable period of 7 years under Section 183 of the Constitution. Now, it's conceivable that a public protector may develop a condition which, although temporary, impairs their ability to perform their work and is likely to continue doing so for the balance of their term of office, or perhaps for a significant portion of their term, say the next 2 years. If in such circumstances the public protector doesn't request the Assembly's permission to vacate their office on account of continued ill health in terms of Section 23A of the Public Protector Act, it would be rational and consistent with Section 1941A of the Constitution for the Assembly to remove them from office on its own accord. That brings me then to the third challenge to the rules, and that is that they are unreasonable because she cannot be expected to conform to the new requirements imposed by the definitions of the rules at a time before they came into existence. Just a word about unreasonableness. Unreasonableness is a ground for judicial review of administrative action. It is not a ground on which the rules can be reviewed. But we understand the gist of this point. It's because it also underlies the applicant's claim for the first alternative order she is seeking, namely one declaring that the rules do not operate in relation to her actions before the 3rd of December 2019. It's the issue of retrospectivity, which we deal with in our main heads, paragraphs 192 to 194, and in our supplementary heads, paragraphs 5 to 15. The fundamental problem with this reasoning is that it mistakenly presupposes that the new rules themselves are the source of the Assembly's power to remove office bearers in terms of Chapter 9, to remove Chapter 9 office bearers from office on the grounds of misconduct, etc. They are not. The power derives from Section 194 of the Constitution, which came into operation on the 4th of February 1997. The new rules merely particularize the elements of the grounds for removal and elaborate on the mechanism for removal in Section 194. And once it's submitted as we accepted as we submit, it should be that the date on which the Constitution came into effect is the date from which the Assembly became empowered to remove an office bearer of a Chapter 9 institution in terms of Section 194, and not the date on which the new rules were adopted. The retrospectivity point simply does not arise. Moreover, as the full court pointed out in paragraphs 98 to 100 of its judgment on the relief the applicant is seeking in Part A, that's now reported as Public Protector and the Speaker of the National Assembly and others 2024, All South Africa Report 776, Western Cape Court. 4 points. First, with the exception of criminal trials, as to which we refer the court to Section 35(3)(L) of the Constitution, there is no rule against retrospectivity in our law. There's a presumption, but it can be rebutted either expressly or by necessary implication by the provisions or indications to the contrary in the enactment itself. That's Workmen's Compensation Commission and USTA, 1997 4 SA 418, SCA at 424G. Secondly, one of the circumstances in which such an inference can be drawn is when holding that a measure is not retrospective would lead to an absurdity. That's Leck and the Estate Agents Board, 1978 3 SA 160C at 169 F to G. Thirdly, in our submission, it would be absurd, and this is what the full court held, to interpret the new rules as applying only to events after their adoption. If the new rules didn't operate retrospectively, in the sense of regulating the grounds and process for the impeachment of a Chapter 9 office bearer based on their conduct or performance in the period after their appointment, but before the adoption of the new rules on 3 December 2019, the result would be the following. Because the adoption by the Assembly of those new rules is a requirement for all impeachment proceedings under Section 194, that's the EFF impeachment case, no misconduct committed by a Chapter 9 office bearer during that period, or no incompetence manifested by a Chapter 9 office bearer during that period, however grave, could sustain their impeachment.
Mr. Reichenbach, yesterday the applicants have been simple measure for the National Assembly to just include retrospectivity in if they want to in it. And the addition thereof, bearing in mind at the time when they were looking at the rules, it was already a complaint.
I understand that, but of course it falls because the contention yields the absurdity to which I've just referred. There's no need to say something expressly if it would be absurd to interpret the rules in a contrary fashion. We respectfully commend the reasoning of the full court to this court on that issue. But there is a further reason, which I'll get to, which relates specifically to the content of the rules, and these are the last 2 points. The first thing is the court knows that the rules mainly regulate the procedure to be followed in the future, in other words, after 3 December 2019, for impeachment processes in terms of Section 194 of the Constitution. We've seen what that procedure entails. Insofar as the rules deal with matters of substance, in other words, define incompetence, misconduct, or incapacity, as explained earlier, they impose higher thresholds for impeachment than the ordinary meaning of those words would otherwise impose, and that's in the case of incompetence and misconduct, or don't alter the threshold in the case of incapacity. Consequently, if anything, the new rules favour the incumbents of Chapter 9 officers by making it more difficult to remove them on the grounds of incompetence or misconduct. And the important point is that issues of retrospectivity arise only in respect of changes to the law which would impair existing rights or create new obligations. which is not something that the new rules do in any presently relevant sense, because the retrospective operation of the new rules, if anything, inures to the benefit, or at least not to the detriment of Chapter 9 office bearers. And we refer to ex parte Christodoulides' 1959 3 SA 838T at 841A to B. Ultimately, yes, it is a question of construction. And there are two ultimate problems here. One, the grounds of impeachment have existed since February 1997. So it's not a question of retrospectivity imposed by the new rules. Secondly, it would be absurd to interpret them as not applying to misconduct, etc., committed during an office bearer's term of office, however grave that may be. And I suppose a third factor that the court can take into account is the court knows the facts. What happened was, shortly after the constitution of the 6th Parliament in May 2019, the then Chief Whip of the DA, Mr. Steenhuisen, lodged a motion for the removal of the applicant as public protector. The public protector wrote to the Speaker in early July 2019 about that, making a number of points, one of which was that the process would be incompetent unless and until new rules dealing specifically with impeachment under Section 194 were adopted. The Speaker referred that matter to the Portfolio Committee on Justice, which essentially agreed and advised her to refer the matter to the Rules Committee of the NA, which she duly did. It itself and through a subcommittee then set about preparing these rules so that there would be a set of rules in place to deal with the removal of Chapter 9 office bearers. The context, in other words, the factual context in which this occurred was against the backdrop of Mr. Steenhuisen's motion, which, as the court knows from the papers, was largely similar to the current motion. The latter has added further events, but the events preceding May 2019 are there too. That is to the extent that the facts might further assist, but the two fundamental points I've made remain. That brings me to paragraph 60. This challenge, the fourth challenge, wasn't persisted with in oral argument, and I shan't therefore address it in oral argument. And that is that the rules are specifically targeted against Advocate Mkhwebane as an individual, in spite of being clothed as rules of general application to all Chapter 9 office bearers, the so-called Sobukwe clause argument. If I could ask the court to turn to page 24 at paragraph 65. The fifth challenge then is that the new rules do not differentiate between the requirements for the impeachment of the President in Section 89 of the Constitution and the requirements for the impeachment of the holder of a Chapter 9 office in Section 194. We deal with this issue in paragraph 208 of our heads of argument. The short answer is that in drafting and adopting these rules, the Assembly acted rationally, and the rules are themselves rationally related to Section 194. We refer the court in this regard to the detailed description of the process of the formulation of the rules in paragraphs 80 to 92 of the Speaker's answering affidavit, where the members of the committee, and particularly the subcommittee of the Rules Committee, gave careful consideration to a set of rules that would fit and regulate the impeachment process in Section 194 of the Constitution. We've already looked at some length at the definitions of misconduct, etc. in the rules, and also we refer the court to the description of the interaction between the rules in Section 194 in our heads in paragraphs 119 to 144. That's the 17-step process. There can be no doubt that there is a close fit. They are fit for purpose. They meet this test of substantial rationality, in other words. The sixth challenge is in paragraph 68, also not persisted with in oral argument, was that the rules are irrational because they failed to make provision for filtering malicious and or dishonest complaints by conflicted and compromised individuals or any other abuse of process maneuvers. That argument wasn't persisted with, perhaps wisely, but if to the extent my learned friend would like the court to deal with it, the answer is summarized in paragraph 69 and 70, to which I shan't address argument now. The seventh challenge, paragraph 71. This challenge was emphasized quite considerably yesterday. It's that the new rules deny the applicant the benefit of audi alteram partem because they do not make any provision for her to be notified by the speaker of a complaint in the form of a motion that has been lodged against her. Now, we deal with this issue in our main heads at paragraphs 161 to 162. Generally, as regards this challenge, for the reasons given earlier, we submit that as the implementation of the rules is not administrative action regulated by Section 33 of the Constitutional PAJA, the applicable standard is procedural rationality and not procedural fairness. The second point that the court will have seen from the speaker's affidavit is this. She accepts that the participation of Advocate Mkhwebane in the Section 194 process is necessary for it to fulfill its function as the Constitution's ultimate accountability enhancing mechanism for Chapter 9 office bearers. In other words, she accepts that the participation of Advocate Mkhwebane in the process is necessary for it to be procedurally rational. There is, however, no question of the office bearer being excluded from the process and consequently of the process being procedurally irrational. The reason for that is the new rules provide the office bearer with two opportunities to answer the charges against her. The first one is when the independent panel conducts the preliminary assessment of whether there is a prima facie evidence to show she committed the misconduct with which she has been charged or is incompetent for the reasons alleged. We refer in this regard to rules 129X, 1C, 2 and 3, Roman 2 and 3. During the independent panel proceedings, the office bearer will be at liberty to assert and seek to establish that the motion is non-compliant, either because it does not meet the form and content requirements of Rule 129R, or because it is inconsistent with the Constitution, the law, and/or the new rules. The second opportunity is during the proceedings of the Section 194 committee. We refer in this regard.
I understood the complaint to be twofold. One, before the speaker decides that the motion is in order, before that process, there is a courtesy not even to say there is this motion that I'm going to consider. I further understood the complaint there to be the whole country knows. You could be walking down the passage in your office and your subordinate said, do you know this is against you? That's the one complaint, the way I understood it. The second complaint, the in-order decision affects the incumbent directly and can affect the incumbent negatively. If the incumbent at that point can make an in, we might never get past that step.
And I think I understand those 2 points, and I have categorized them as attacks on the speaker's decision to approve to hold that the motion was in order. And with your leave, I shall deal with them. I deal with them in detail when I get to that aspect of the case. So, thank you. The second opportunity which the incumbent has to answer the charges against her, as the court knows, is during the proceedings of the Section 194 committee. We refer to Rules 129A sub 2 and 3, which provide that the committee must ensure that the inquiry is conducted in a procedurally fair manner and afford her the right to be heard in her own defence. Finally, in this regard, the applicant seeks to make something of the fact that on the 26th of February 2020, the Speaker decided to provide her with copies of both of Ms. Mazzoni's motions. We'll deal with this later when addressing her claim for personal and punitive costs against the Speaker, this being the first of the factors on which she relies for that. Her eighth challenge to the new rules, and I'm sticking just to challenges to the new rules rather than to their administration or implementation, is they do not provide for her to be given reasons for decisions adverse to her. Now, we deal with this in our main heads at paragraphs 179 to 181. For two main reasons, we submit that Advocate Mkhwebane, like the incumbent of any other Chapter 9 office whose impeachment is sought, has no right to reasons for any of the following decisions. This is no right to reasons contemporaneously at the time. Quite a different matter whether the decision can be justified, of course, and this is the ultimate decision, if there aren't good reasons for it, and that's something to which I shall come at a moment. No right to reasons for a decision of the Speaker in terms of 129S that a motion for the removal of the office bearer is in order. The second is a decision by the independent panel that there is prima facie evidence substantiating the charges, although the rule does require the panel to submit a report to the NA, which must include the reasons for its recommendations. So the rule requires that the NA be given reasons for the recommendations. So it has the right to those reasons, and indeed, as you will know from my answers earlier to Justice Delamo, the whole point of the exercise is that a reasoned recommendation is given. Thirdly, to a resolution by the Assembly in terms of 129Z that a Section 1794 inquiry be proceeded with. Fourthly, to a decision by the 194 Committee in terms of Section 1941B and Rule 129AE that the office bearer has committed the misconduct or is incompetent or incapacity for the reasons alleged in the motions. But here again, Rule 129AF does require the committee to submit a report to the NA, which must include the reasons for its findings. So again, the National Assembly is entitled to reasons so it can make an informed decision, and the decision in question is a resolution by the Assembly that the office bearer be removed from office in terms of 194(1)C, 190 Rule 129AF2. The first reason why the office bearer is not entitled to any reasons is that none of them, these decisions or resolutions, is administrative action subject to PAJA, sections 5 of which confers a right to reasons for administrative action. The second reason is that there's no requirement in the Constitution or in any other law or in the Assembly rules that reasons be given, and I stress, to the office bearer for the decisions or resolutions. Nor does procedural rationality or any other constitutional rule or principle applicable to the impeachment process require the giving of reasons to the office bearer. But, and here I emphasize, where the Assembly itself requires reasons in order to fulfill its functions in a rational manner, reasons for the independent panel's findings and recommendations, and reasons for the Section 194 Committee's findings, the new rules expressly provide that their reports to the Assembly must contain the necessary reasons. And as the proceedings of the plenary NA and impeachment matters will invariably be conducted in an open manner, the office bearer will be entitled to access those reports. And then just coming to the point which is not in the note, but which I alluded to earlier. Finally, in this regard, I should mention that should a Chapter 9 office bearer challenge a decision to remove them on the ground that the decision by the Section 194 Committee is arbitrary, in other words, that it arbitrarily decided that they committed misconduct or were incompetent or incapacitated, the committee's reasons for its decision in its report to the Assembly must be plausible, because if they aren't, the arbitrariness challenge will succeed for the reasons that the court will know from judgments like the restructuring insolvency practitioners case to which I referred otherwise. And that's an important point to bear in mind. And we are dealing here with a process which is aimed at an assessment, a rational assessment of whether or not an incumbent office bearer should be removed. The process provides for the participation of the office bearer in the screening stage. In other words, a right to be heard by the independent panel before it makes its findings and recommendations to the Assembly, and of course, to participate in a Section 194 committee if that arises. The process provides that the independent panel must report to the Assembly and give reasons for its recommendations. Process also requires that the Section 194 committee must report to the Assembly and give reasons for its findings. That's as far as the process is concerned. So those reasons will become public in the course of the process. If the reasons by the latter, the committee, are arbitrary for those findings, well then of course the removal, any removal of the office bearer based on arbitrary reasons cannot stand, because our Constitution has it against arbitrariness. It's one of the fundamentals of legality. And in that respect, and to that extent, the office bearer is, of course, entitled to consider and challenge the decision on a ground of arbitrariness. But that comes after the fact. That brings me to Advocate Mkhwebani's 9th challenge to the rules, and it's one which concerns provision being made in Rule 129V for a judge to be appointed to the independent panel in consultation with the Chief Justice. And the contention is that that violates the principle of the separation of powers between the judiciary and the legislature. She also contends that no law authorizes the Speaker to appoint judges to parliamentary structures. It's convenient to deal with the first of those. Oh, I apologize. We deal with them in our main heads at paragraphs 210, 211, and in our supplementary heads at paragraphs 31 to 38. It's convenient to deal first with the lack of formal authority. In other words, your contention that no law authorizes the Speaker to appoint judges to parliamentary structures. The answer to that is in line with EFF impeachment. The new rules regulate the process in the Assembly, including the two sifting mechanisms to determine whether the Chapter 9 office bearer has a case to answer. As the court knows, the second of these is the appointment of the independent panel to assess whether there's prima facie evidence supporting the charge or charges. The adoption of by the Assembly of rules regulating that process was something which the Assembly was obliged to do, and it follows from that, we submit, that the rules can validly provide the authority to appoint A, the independent panel, as I discussed with Justice Lama, or B, a judge to the independent panel. Having said that, there may be separation of powers implications for that. And this point is the real gravamen of the complaint here. Now, before dealing with the applicable legal principles, we point out something which may have been a misconception in the debate yesterday. If one has regard to Rule 129V of the rules, it provides that while the Speaker is obliged to give due consideration to all persons nominated by the political parties represented in the Assembly, it does not say she's obliged to appoint the independent panel from among the nominees. She calls for nominations, but she alone decides who the panel shall be. And that is one of the safeguards to avoid the perception that might be created that this is the UDM judge or the PAC judge. I think the submission was yesterday.
No. She is judge. She had two appointed judges. Bearing in mind
Justice Bartman, I'm sorry to interrupt you. Would you mind starting again? I missed everything that you said at the beginning.
Oh, okay, sorry. Is that better?
Much better.
Yeah. That does not take away the danger that people will say, oh, the Speaker appointed her own judge. Consider in your answer that the judiciary has come under attack from all quarters as of late. You say this is a political decision that must be made. We really want a judge up front in this climate that we do, especially. Consider that in your.
Thank you, I shall. And there is a second safeguard, which I submit deals with that problem. I think it's first appropriate to deal with the applicable legal principles, and we rely on the summary of those principles in National Society for the Prevention of Cruelty to Animals versus the Minister of Agriculture, Forestry and Fisheries case 2013-5 SA 571 CC. The other important case is South African Association of Personal Injury Lawyers versus Heath and others 2001 1 SA 883 CC. We give some references in what follows. Our core submission is that our model of the separation of powers is not one that requires a complete or total separation. It permits the performance of some non-judicial functions by the judiciary, especially if they are closely connected with the core functions of the judiciary. And our submission is that the Assembly may validly make provision for the Speaker to enlist a member of the judiciary to participate in the non-adjudicative screening function entrusted to the independent panel. And the essential reason is that the performance of the panel's function, focused as it is on the determination of whether there's prima facie evidence to show that the holder of a Chapter 9 office committed misconduct, is incapacitated or is incompetent, that is compatible with the office of a judge and will not be harmful to the institution or central mission of the judiciary. More specifically, the performance of that function calls for qualities and skills required for the performance of judicial functions, including independence, the weighing up of information, and the forming of an opinion based on information. In other words, and this is to use the wording of the cases, it's a function closely connected with the core function of the judiciary. But here comes the safeguard to which I referred in a moment ago in answer to the question put to me by Her Ladyship presiding. In order to ensure that the appointment of a judge to the panel does not disrupt the proper functioning of the court of which they are members or imperil the independence of the judiciary, Rule 129(v)(3) expressly provides that if a judge is appointed to the independent, the panel must do so in consultation with the Chief Justice. Now, that phrase, in consultation with, means that the Chief Justice's consent is required. It follows that no judge may be so appointed unless the Chief Justice, who is the head of the judiciary, agrees. This safeguard we submit deals with the point raised in argument yesterday, namely that the appointment of a judge nominated by a particular party may give rise to an incorrect perception that the judge is aligned with the party in question, and it will also, I respectfully submit, deal with the point raised by Her Ladyship presiding. If the climate at the time is such that it would be inappropriate and it may imperil the independence of the judiciary for any judge, regardless of who nominated them, the Speaker's own selection to be appointed, the Chief Justice can say no. The Chief Justice obviously being someone who will be anxious to safeguard the independence and perceived independence of the judiciary. As to the facts, as appears from the Speaker's affidavit of 2 June, in the present case, she did not appoint any serving judge to the independent panel. She appointed 2 senior counsel and a retired justice of the Constitutional Court, Justice Nkabinde, who has been discharged from active service as a Concord judge and is not performing active service as a judge in any other court. And we submit that the appointment of Justice Nkabinde did not implicate the separation of powers. And indeed, I would go so far as to say that the eminent composition of that advisory panel shows the value or the benefit of receiving independent and expert advice in a serious matter such as this one. Yesterday, my learned friend placed a heavy reliance on the Amabungani case. The lace it's very long. The record reference is 2021, Volume 3, SA 246, Constitutional Court. It's in our bundle at page 887. That case concerned the definition of designated judge in Section 1 of the Regulation of Interception of Communications and Provision of Communication-Related Information Act 70 of 2002, which is commonly known as RICA. The definition conferred on the Minister of Justice the power to designate any judge of the High Court discharged from active service under Section 3.2 of the Judges' Remuneration and Conditions of Employment Act 47 of 2001, or any retired judge to perform the functions of a designated judge for purposes of RICA. Generally speaking, those functions entail issuing directions, authorizing various types of surveillance, including directions for the interception of communications. Now, in Bungani, the Constitutional Court upheld a finding by the High Court that RICA failed to ensure the independence of the designated judge, basically for two reasons in our respectful submission. The first, as the court said in paragraph 92, is the following. At present, the designated judge is appointed by the Minister of Justice, a member of the executive, without the involvement of any other person or entity. And in practice, terms of designated judges have been renewed. Also, the lack of specificity on the manner of appointment and extensions of terms raises independence concerns. The second in paragraph 93. Additionally, surveillance directions are sought and issued in complete secrecy and therefore without public scrutiny or the possibility of review or appeal, which points to a lack of mechanisms for accountability and oversight. We however submit the appointment by the Speaker of a judge to the independent panel in terms of Rule 129V is not comparable to the designation of a judge by the Minister under RICA, and neither is the functioning of the independent panel under the new rules comparable to the functioning of the designated judge under RICA. The reason is the new rules contain 6 important safeguards. First, before making the appointments, the Speaker must consider nominees put forward by political parties represented in the Assembly. Secondly, the new rules specify objective criteria for appointments to an independent panel. Namely, the panel must consist of 3 fit and proper South African citizens who collectively possess the necessary legal and other competencies and experience to conduct the assessment described in Rule 129X. Third, as we've already mentioned, if a judge is appointed by the Speaker, the appointment must be made in consultation with the Chief Justice. Fourth, the judge and the other members of the independent panel are appointed for the purpose of evaluating a specific complaint and not for a term of office. Fifth, the independent panel must provide the Chapter 9 incumbent with copies of all information available to the panel relating to its assessment of the motion, proposing a Section 194 inquiry, and secondly, must provide the incumbent with a reasonable opportunity to respond in writing to all relevant allegations against him or her. And sixth, the panel must produce a report containing recommendations which must be tabled in the Assembly. So for those reasons, we submit that the Amabungani case concerns a statute which is entirely distinguishable. Here there are more than sufficient safeguards for the independence of the judiciary. If, however, contrary to our submissions, this court were to uphold the separation of powers challenge to the new rules, it could simply sever the relevant parts of Rule 129V, in other words, the phrase which may include a judge in Rule 129V1, and of course the whole of Rule 129V3, which is the one dealing with the consent of the Chief Justice being required. We submit that severance would be appropriate. We refer in this regard to Coetzee and the Government of the Republic of South Africa, 1995 4 SA 631 Constitutional Court, paragraph 16. It's unfortunately not in our bundle, but the test for severance is set out there. This is, the court said, although severability in the context of constitutional law may often require special treatment, in the present case, the tried test can properly be applied. If the good isn't dependent on the bad and can be separated from it, one gives effect to the good that remains after the separation, if it still gives effect to the main objective of the statute. Here it will obviously read the rules. That brings me to the 10th challenge, which is one which wasn't pressed in argument, namely the rules unfairly deny Advocate Mkhwebane the right, as it's claimed, to an oral hearing by the independent panel. I shall pass over that as it wasn't pressed and go to the 11th challenge, para 102 of my note at the bottom of page 34. That is the challenge that the rules unfairly deny her the right to full legal representation before the Section 194 committee. In other words, to a legal representative who may speak on her behalf and not just assist her. We deal with this issue in our main heads at paragraphs 183 to 188. It concerns Rule 129 AD sub 3, which provides that the Section 194 committee must afford the holder of a public office the right to be heard in his or her defence and to be assisted by a legal practitioner or other expert of his or her choice, provided that the legal practitioner or other expert may not participate in the committee. In other words, this challenge is directed to the proviso. The issue is whether this restriction in the proviso on the committee's functioning is rational. We submit it is because, as the Speaker has explained in her answering affidavit at paragraphs 179 to 180, and in her supplementary answering affidavit, paragraph 66.1, the new rules rationally require that a Chapter 9 office bearer must participate personally in the proceedings of the Section 194 committee and not do so through a legal representative participating on their behalf.
Very important. Personally, she participates when she reports. Part of the oversight function, when she presents the various reports and even answer to what's happening in the public, court judgments against her, court pronounced on her, she personally managed it. Here she is an accused. She might choose not to personally to present oral evidence herself. She might choose to read evidence. Somebody needs to cross-examine those for oral hearing, which I'm sure it will. She might not be the best person to cross-examine.
So the answer to all of that is the following.
I accept that she'll be competent to do that. The Speaker sets out, she's got 10 years, but it might not be the best thing for her to do at that.
The answer to that is the following. You will recall that the principles that we started, that we distilled from the classes, include as one of them that these rules, that Section 194 is the ultimate accountability mechanism, and that's to use the words of the Chief Justice in the UDM case. What happens in an instance like this is that the National Assembly is holding the incumbent to account. Yes, in the context of a possible sanction, their removal from office, but it remains an accountability mechanism. It is no different from the accountability, the regular accountability to which your ladyship has just referred. And the Assembly has decided that because the incumbent must account personally, she must participate personally in this ultimate accountability mechanism. What the Assembly is anxious to avoid, may I just finish, is the spectacle that, such as one saw in America twice, where the previous president was impeached twice, and on neither occasion did the president set foot in the chamber which was considering the question of his impeachment. Our constitution is different. It requires these individuals to account to the Assembly.
Yeah, but I just say, I have no problem with the accounting to the Assembly. The Assembly has mechanisms to secure the president. I see from the affidavit of the Speaker that is exactly their problem. She's not allowed to have full legal representation, and she might not show up. They have mechanisms to secure a presence.
With respect, that is not the Speaker's. That is not a fair summary of the Speaker's position. A charge has been levelled against her that she has misconducted herself. Take the example in her investigation and report and the ensuing litigation of the Freda Dairy matter. It's alleged that she didn't do what she was supposed to do when investigating. It's alleged that in conducting her litigation, she misconducted herself in the court proceedings. Those charges have been levelled against her, and the rules of the Assembly requires that she personally accounts for that in the committee, which must decide whether she is guilty or not. She's entitled to participate, and doubtless evidence will be led, and she will have the opportunity to defend herself. To do so by cross-examining witnesses if necessary, asking them questions to disprove the allegations which have been leveled against her, and of course to testify in her own defense, if I can call it that, to give evidence as to why she didn't in fact do what was found by the judges in the relevant case. It's a matter of personal accounting, but I suppose it ultimately reduces to this. One is dealing here with a rationality assessment, and what the court must consider is whether there is a rational basis for the Assembly's insistence that the accountability be personal. That's the question. And we submit that there is indeed a rational basis for that. And we do also commend to the court a contextual interpretation of this requirement.
Sorry to interrupt you. What I have no problem with the actually assembly requiring presence and personal accountability. She would have to testify about all of this, and it would take the whole morning just to go through the evidence. What is the rationale for saying your counsel cannot lead you? You might forget half the evidence. This is a very charged proceeding. Why can somebody not need her to put all of that on the record? That rationality I cannot see.
The answer to that is that she must explain for herself. She mustn't be led by someone else. She mustn't have someone else asking questions of witnesses on her behalf. She must explain to the committee why it is that she is not guilty as charged. She can bring whatever witnesses she wants because of there's another feature which I would emphasize, is one mustn't look at this in isolation from its context. The rest of the context of the rule 129A is important. This provides that the committee has a duty to ensure that the inquiry is conducted in a reasonable and procedurally fair manner. So it's not a free-for-all. It's expressly stated, in fact, in 129AD2, and it was highlighted by the full court when dealing with this very issue in paragraph 89 of its judgment in respect of Part A. So the bottom line is this: while the Assembly has decided that the committee may not permit a Chapter 9 office bearer's legal representative to participate in the proceedings of the committee, what we submit is permissible is, and this is in the Speaker's affidavit, is should a situation arise, perhaps it's in our heads, where reasonableness or procedural fairness require that the office bearer be afforded time to consult with their legal representative before proceeding, for example, before questioning a witness against them, either generally or on a particular issue, a reasonable or fair period must be afforded to them for that purpose. So there is a built-in requirement of reasonableness and fairness. What there is a restriction on the process being lawyered up, as we have seen elsewhere. That's the Assembly's choice. The question is it rational? The question, that is the ultimate question, is it rational? Rationally related to gathering the information necessary, because that's what procedural rationality is focused on, for an informed decision to be taken.
Potentially, you are extending per witness the inquiry with 4 days to sit down and take notice from your attorney how to put questions in which questions to put. In your team, you might not be the best cross-examiner for that particular witness. Why can the counsel not cross-examine the witness? The Assembly wants the witness. The witness is testifying. She is present. He is present, whoever the incumbent is.
You're undoubtedly right that another way of doing this may be to allow the person to be represented by a lawyer who will participate in the committee. There are reasons which go either way. That ultimately, however, is not the question. The question for decision by this court, and this is a serious element of the separation of powers, is simply whether it is rational, because the Constitution has entrusted the process to the National Assembly itself to decide. She's accountable to the Assembly, and there is a limit with respect to the extent to which the court can second guess the Assembly's choice in this regard.
You can can see that I'm struggling with the rationality. The lawyer is there, now we must adjourn for 2 days so that he can tell me how to ask questions. He can ask a question. I am there incumbently present.
The answer to that, it can be addressed by setting up the inquiry in such a way that, for instance, witness statements from the persons who are going to give evidence must be supplied in advance. We see that, for instance, in many of our commissions of inquiry, including the one into state capture, so that the person can in advance, well in advance, consult with the lawyer, not be ambushed. There'll be no need for any lengthy adjournments. It really, that's a matter of detailed operationalizing. Properly structured, this can proceed in an expeditious way and allow the person an opportunity fully to defend herself or himself against the charges. It doesn't have to be dealt with on the hoof as your ladyship's question implies.
Mr. Breitenbach, I have your submission, just one for a step off from it. There are teams here, each consisting of 3 counsel. The lead counsel is not necessarily the most competent to the cross-examination.
Undoubtedly, in my case, I'll defer to my 2 juniors on that.
Okay. Incumbent might like the same privilege. As did.
Just before you proceed, Mr. Breitenbach, can you hear me?
Yes, I can. Thank you.
I understand that the rationale for excluding participation of legal representatives in the proceedings in the assembly is based on the fact that the incumbent, the Chapter 9 head, must account himself or herself.
Yes.
But now, if she is present, as my sister has postulated, and when it's time for her to answer questions, she answers questions with the assistance of a legal representative. How does that defeat the rationale of that? Cannot be self-defeating. She's accounting personal.
I strongly suspect that the chair of the inquiry, if the situation arose where a question would be put to her and she would first confer on each and every question, and then, as if a ventriloquist's dummy would repeat what she has been advised to say by her lawyer, may put his or her foot down and say, we do want to hear from you yourself. What is your answer to the following charge? Take the charge, for instance, that you wrongly said in your affidavit in these proceedings that you met with the president on one occasion, whereas in fact it turned out there were 2 meetings with the president, or whatever the charge may be. So again,
I'm not sure if you understand my question. My question is, she is present during the proceedings.
yes,
When time for her to give evidence, she gives evidence led by a counsel. When it is time for the cross-examination is done by counsel, she is still accounting personally. She is present in those proceedings. What would still be the rationality of excluding that participation of the legal representative? In circumstances where you have the Chapter 9 head present during those proceedings, when it's time for her to answer, she answers personally, but then when it's time to cross-examine, because she might not be able to do that, she's assisted by the counsel.
I can take the matter no further. The choice of the assembly, it's a conscious choice, is that she herself must be the person who participates in the committee, she alone. And that is on the basis that she is personally accountable to the committee. They've decided no one else may speak on her behalf during the course of the proceedings. I wish to make 2 further points in this regard. The first is that there's reliance placed on the case of Hamata, 2002 5 SA 449 SCA. We submit that reliance is misplaced. In that case, the SCA held that the interim constitution did not recognize an absolute right to legal representation outside criminal proceedings, and we submit the same applies to the final constitution. Moreover, the dictum on which she relies, that's in paragraph 13, pertains to legal representation before administrative bodies, which we are not dealing with here. The second point I wish to make is that she has sought to make something of the fact that the rules governing the process for the impeachment of the president in terms of section 89 don't contain the restriction in question. As the Speaker points out in her supplementary answering papers at paragraphs 97.1 to 97.3, however, the criticism is misguided because the test is not whether the NA could have included different mechanisms to the one it did, but whether the new rules contain a rational scheme for the conduct of the proceedings in a section 194 committee. And I've already submitted that the Speaker's explanation of personal accountability is a rational one. If, however, the court were to uphold this challenge to the rules, it is again a case where severance would be the appropriate remedy. It could simply sever the relevant part of Rule 129 AD3, in other words, the proviso from the rule, and we submit that severance would be appropriate.
Yesterday, we were cautioned to get figures. Please don't start snipping, send it back, let them start from scratch. What do you say about that? Can you not on this one issue?
That one only does that if severance is inappropriate. And severance is appropriate where an isolated defect is identified, and to use the words of the court in Kutsia's case, the good, in other words, what remains, is not dependent on the bad and can be separated from it. And importantly, if what remains still gives effect to the main objective of the measure. So I'm submitting to you on behalf of the Speaker that if you're against me on this point, it is an isolated qualification. It's a proviso which could be removed and that the rules could continue, the good can continue through the simple device of severance. This is not something which is fundamental and cuts through the entire process regulated by the rules, starting with the definitions through to the initial screening of the motion by the Speaker right out the other end with the decision of the committee. It's a confined challenge to a proviso to one of the sub-rules of one of these rules. The 12th and last challenge to the new rules is they don't preclude or contain safeguards against the participation in the section 194 process of members of the Cabinet against whom complaints have been lodged with the Public Protector, which are being investigated by her, or who are currently involved in acrimonious litigation against her. In other words, people who may reasonably be suspected of bias against her. More specifically, she alleges that the rules don't contain safeguards against the involvement of persons who may reasonably be suspected of bias, and she then tells us who they are. The first is the Speaker, due to her ongoing involvement in the Bosasa case. The second is on the part of the National Assembly members. Incidentally, as far as the Bosasa case is concerned, that case was heard at the end of last year and judgment was reserved by the Constitutional Court. The second is on the part of the Assembly members who may be under investigation by the Public Protector or involved in litigation against her. And the third is on the part of the members who in the past have criticised her CIEX, that's the Absa Bank lifeboat and Freda Dairy investigation reports. And the complaint is that the rules don't require these people to recuse themselves. Now, we deal with this issue at some length in our heads at paragraphs 222 to 245. I'd like to deal first with the section 194 committee. And in that regard, we submit that some guidance can be obtained from the judgment of the full court in the matter of the President of the Republic of South Africa and the Public Protector and others, 2018, Volume 2, Essay 100, Gauteng, Pretoria, paragraphs 130 to 137. That case was the one which concerned the current Public Protector's predecessor's state of capture report, and specifically the recommendation that a commission of inquiry be established to investigate what the Public Protector had found to be evidence of what's now known as state capture. One of the issues was who should appoint the Judicial Commission of Inquiry. It is something which the President does under the Commissions Act, but the Public Protector ruled that would not be appropriate because the then President had been implicated in the report by some of the alleged instances of state capture. And so what the Public Protector recommended was that the Chief Justice appoint the Commissioner. And the issue was whether that would be appropriate, and the court held that it was appropriate relief within the meaning of Section 180 to 1C. The Public Protector may take appropriate remedial action because of the perception of bias that would otherwise attend to the President's discharge of that function. Now we submit that learning does assist with the committee. In other words, we accept that procedural fairness and procedural rationality require that the members of the committee should not have or be reasonably perceived to have a personal interest in the outcome of the proceedings of the committee. The reason is the function of that committee is to make a finding as to whether or not the office bearer has misconducted themselves or is incompetent or incapacitated on the grounds set out on the charges. In instances where the facts are in dispute, this will entail both fact-finding and determining whether facts as found show misconduct, incompetence, or incapacity. And in that context, we submit, in other words, that people who have or may reasonably perceive to have a personal interest in the outcome of the committee should not participate. The principle against bias, we submit, operates there. So the important thing there is that the political parties represented in the Assembly must therefore ensure that the members they appoint to serve on the committee should not have or be reasonably perceived to have a personal interest in the outcome of the committee, of its proceedings. This then brings us to the participation of members in the impeachment process in the Assembly as a whole. In other words, when the Assembly is in plenary. We know that happens on two occasions. The first is to decide whether the matter should go to a 194 committee, and the second is when considering the findings and report of a 194 committee if the matter proceeds that far. And specifically here, obviously, the issue is voting on an impeachment motion in the Assembly. We submit that when dealing with this issue, the rules cannot be considered in isolation from Section 194 and the remainder of the rules. The reason is Section 194 requires that the Assembly as a whole must decide whether or not to remove a Chapter 9 office bearer from office. And we know that in the case of the Public Protector and the Auditor General, the threshold for their removal is a supporting vote of at least 2/3 of the 400 members of the Assembly. And in the case of the others, it requires an absolute majority, a majority, in other words, of 201 plus of the members. The core submission here is it would be inimical to the proper functioning of the impeachment mechanism and to our system of party political representative democracy if members of the Assembly were to be precluded from participating or voting in the proceedings of the Assembly relating to the impeachment of a Public Protector, simply because they know or have reason to suspect the Public Protector is investigating complaints against them, or because they're involved in litigation against the Public Protector involving reports containing findings of wrongdoing by them. In other words, in our submission, it's necessarily implicit in Section 192(42)A of the Constitution that all the members of the Assembly are entitled to vote on a motion for the impeachment of the Public Protector. And I've already submitted that voting on such a motion entails an exercise of political judgment, more specifically whether the misconduct, capacity or incompetence as found by the committee are so serious that removal from office, which is the ultimate accountability mechanism provided by Chapter 9, is warranted. This means that when voting on such a motion, all members must put the public interest ahead of their personal interests. And that's where the rules of the NA come into play. Rule 30 of the National Assembly rules and the Parliamentary Ethics Code, which the court may wish to note is Annexure TRM 71, it's at volume 7, page 591. They provide that if a member has a personal interest or a private financial or business interest in any matter before a forum of the Assembly of which he or she is a member, he or she must at the commencement of engagement on the matter by the forum immediately declare the interest in accordance with the Code of Conduct contained in the schedule to the joint rules, and comply with the other provisions of the Code. The Code's the Parliamentary Ethics Code. And in line then with the oath or solemn affirmation taken by all MPs before they may perform their functions as such, which is in item 4 of Schedule 2 to the Constitution, the Code then outlines the minimum ethical standards of behaviour that all South Africans expect of public representatives, including upholding propriety, integrity, and ethical values in their conduct. And it specifically provides that all members must take decisions solely in terms of the public interest and without regard to personal, financial, or other material benefits for themselves, their immediate family, and their business partners or friends. They must declare private interests relating to public duties and resolve any conflict arising in a way that protects the public interest, and they must discharge their obligations in terms of the Constitution to Parliament and the public at large by placing the public interest above their own interests. And a member will breach the Code when they, amongst other things, contravene or fail to comply with the requirements of the provisions for disclosing their interests, or contravene Clause 1, which I've just quoted. There's a committee which may consider complaints of alleged breaches of the Code, or may in fact do so on its own. And if it finds on the balance of probabilities that a member has breached the provisions of the Code, then depending on the provision breached, the committee may impose certain sanctions, including a reprimand in the Assembly, a fine of up to 30 days' salary, or recommend to the Assembly any greater sanction it deems appropriate, in which event the Assembly shall decide on the appropriate sanction to be imposed. In other words, we submit the Rule 30 and the rules and the Ethics Code contain adequate safeguards against conflicts of interest. I've read my learned friend Mr. Budlander's heads. He makes a point referring to, amongst others, Van Rooyen's case. I don't want to steal his thunder. But the fact that the potential for abuse isn't a basis to invalidate the rules. If an abuse does arise, then of course that can be addressed if necessary under these provisions, or indeed if necessary in a court. But that doesn't invalidate the provisions of the rule. In other words, what we are saying is that these rules, I was at pains to emphasize when I introduced them, that they form a part of the NA rules as a whole. They are part 4 of Chapter 7 to the NA rules as a whole. The NA rules contain these safeguards against conflicts of interest, and they must be read with the Parliamentary Ethics Code, which are incorporated by reference in them. I'd like to then deal very briefly with the apprehensions of bias which Advocate Mkhwebane alleges she reasonably holds in the present instance. This is not an attack on the rules so much, but it just goes to the facts of the present case. The first point that we wish to make is that she isn't seeking to interdict the impeachment process, which is currently underway in the NA. And that would have to be the relief that she would have to seek if she were to rely on a particular instance of bias or reasonable apprehension. So we consequently submit that the issue of whether or not her apprehension of bias is reasonable is not an issue relevant to attack on the validity of the rules. But we note that one of the grounds on which she seeks an order reviewing and setting aside the Speaker's decision that Ms. Mazzoni's motion is in order, and it's also a ground on which she seeks punitive and personal costs against the Speaker, is her allegation that the Speaker unnecessarily took sides in the dispute between the President and her in litigation about the Bosasa report. And we'll deal with that allegation in a moment when dealing with those issues. I'd like to just deal very briefly with the possibility of the court not accepting our submission that her allegation that she has a reasonable apprehension of bias on the part of certain members of the NA, besides the Speaker now, is irrelevant to the relief she is seeking. In other words, I wish to make very brief submissions regarding her apprehension of bias on the part of the members of the Assembly who in the past have criticised her reports, and that's the CIX and Freda dairy investigations and reports. And you'll recall that in this regard, she places particular reliance on the meeting of the Portfolio Committee on 6 March 2018. We wish to make 3 points briefly in this regard. The first one, which is rather important, is that the statements ascribed to the Portfolio Committee as a whole by her in her founding affidavit especially in paragraphs 31 to 35, they come from a summary of the meeting prepared by a NGO called the Parliamentary Monitoring Group. It's Annexure PPFA 3 to her founding affidavit at page 95 of volume 1. And it's, as pointed out by the speaker in her affidavit, it is inaccurate in so ascribing the statements to the committee as a whole. What is accurate is the meeting report which follows. That contains an accurate account of what the individual members of the portfolio committee actually said. So the first part was kind of editorializing, and that is inaccurate. What is accurate is the meeting report. And when one has regard to that report, what it reveals is what we've called, what the speaker has called, a robust engagement between certain members of the committee and Advocate Mkhwebane about the Fred Aderi report, about the CIX report, and the litigation in the High Court about it. Now, our submission is that the members of the Portfolio Committee are within their rights to engage robustly with her about her conduct, especially in her capacity as the public protector. And the reason is she's accountable to the Assembly in terms of Section 181(5). And the Portfolio Committee is the organ of the Assembly which is charged with exercising oversight over the performance of her function, and the members of the committee have freedom of speech when doing so. Indeed, when we submit, it's unexceptionable that members of the Assembly at times express strong views on matters of public concern. Our last submission is it would be inimical to the proper functioning of the Assembly if members who have previously had robust engagements with the incumbent public protector in the discharge of their constitutional power and duty to hold her to account were on that account alone precluded from participating in later proceedings concerning her under Section 194 of the Constitution. That brings me to her request for an order suspending the declaration of invalidity for 6 months. For the reasons given in response to her 12 attacks on the rules, we submit all of them are unfounded. And in 2 instances, if the court is against us, that severance would be an appropriate remedy. In the event that one or more of them is, however, successful and she gets what she is seeking, namely the entire destruction of the rules or invalidation of the rules, she asks in her notice of motion for an order suspending the declaration of invalidity she is seeking for a period of 6 months within which the Assembly must effect the necessary amendments. Now, the Speaker agrees that should the court declare the rules to be invalid, it should exercise the discretion conferred on it by 172(1)(b) of the Constitution to suspend the declaration of invalidity for a period of 6 months to avoid a lacuna, to allow the Assembly to correct the defects. And in this regard, we point out that as the Constitutional Court has held in the leading case on this, the State Agency Affairs Board versus Auction Alliance, 2014 3 SA 106 Constitutional Court at paragraph 55, that suspension is not an exceptional remedy. It's an obvious use of the court's remedial power under the Constitution to ensure that just and equitable constitutional relief is afforded to litigants, while at the same time ensuring that there's no disruption of the regulatory aspects of the provision that is invalidated. Now, depending on the defect or defects giving rise to the declaration of invalidity, the court may make a further order reading in a remedial provision or provisions into the new rules or otherwise qualifying them. But before doing so, we respectfully submit it should afford the parties the opportunity to make submissions regarding any changes it intends making. Our last submission on this topic is it's only where the defect or defects found by the court are so fundamental that their continued operation, in other words, that the rules' continued operation in any form would be anathema to the Constitution. In other words, where no reading in of remedial provisions can address the defects, or where a reading in will have unacceptable implications for the separation of powers between the courts and the Assembly, that the court should refuse a suspension. That then brings me to the request for an order suspending the implementation of the new rules. Now, in my learned friend's heads of argument, or through my learned friend's heads of argument, the applicant asks for the first time for an order in terms of section 172(1)(b of the Constitution, suspending the implementation of the rules while the Assembly will be redrafting the new rules governing the section 194 inquiry process. We've dealt with this in our heads at paragraphs 47 to 52, and although my learned friend didn't deal with it yesterday in oral argument, it's a matter of such importance that I do wish to address oral submissions to this court on this aspect today. Our response is as follows. First, as stated, nowhere in her papers has any suspension of the operation of the new rules, as distinct from a suspension of any order of constitutional invalidity of the new rules, been sought. The amended notice of motion is silent on this score, and there are no allegations in any of her affidavits to support such remedy. And because it's been proposed for the first time in written argument, the speaker has been denied an opportunity to address it in her papers, more specifically the suitability of an order suspending the operation of the rules. The belated request for the suspension of the new rules should consequently be disallowed for this reason alone. Secondly, and in any event, for 4 reasons, the suspension of the operation of the rules which she is now seeking would not be just and equitable, and that's the touchstone for any relief under section 172(1)(b of the Constitution. The first is, it would be illogical for the court to order, as she apparently now seeks, that the new rules be declared constitutionally invalid, firstly. Secondly, that the declaration of constitutional invalidity be suspended to allow the Assembly to correct the defect. And thirdly, that the operation of the new rules be suspended while the Assembly corrects the defect. And the reason is that the effect of the suspension of an order of constitutional invalidity is to allow the law, which has been declared invalid, to remain in operation for the stipulated period, or until such time as the competent authority amends the law to remedy the defect, whichever occurs first. Put differently, a suspension of the operation of the new rules during the period of suspension of the declaration of invalidity would have the net effect of a bald declaration of invalidity. And as the court will recall from our submission a moment ago, a bald declaration of invalidity should only be made if the court were to find defects that are so fundamental that the continued operation of these rules in any form would be anathema to the Constitution. The second problem is that a bald declaration of invalidity would result in the re-emergence of the very lacuna that prompted the Assembly to adopt the new rules in the first place. The third is that if the court grants a suspension of the declaration of invalidity, it may do so subject to a reading in which will remedy the defects it found during the period of suspension. A very good example of that kind of order is in the well-known judgment, the Prince judgment, which held that the Drugs and Drug Trafficking Act and the Medicines and Related Substances Control Acts were unconstitutional to the extent that they prohibited the possession and cultivation of cannabis by adults in private for their use in private. And the court suspended the declaration of validity, but read into the statute essentially exceptions to the criminalizing provisions in those statutes, so that the law from the date of its judgment read as read in. Our fourth reason is limiting the inoperability of the new rules to Advocate Mkhwebani's impeachment process alone, which is what is envisaged in paragraph 6 of her counsel's heads of argument, would result in the irrational situation where the new rules applying to every Chapter 9 office bearer except her, and it would be inconsistent with the general principle that a litigant before the court shouldn't be singled out for the grant of consequential relief concerning a generally applicable rule. Rather, the relief should be afforded to all people who are in the same situation as the litigant. That's in the well-known statement in Bulwana and Gwadiza, 1996-1, SA 388 Constitutional Court in paragraph 32. That then brings me to her challenges to the Speaker's decision that Ms. Mazzoni's motion is in order. The operative decision is the Speaker's decision of the 26th of February that Ms. Mazzoni's motion of the 21st of February is in order. It's challenged on 9 grounds, and we shall deal with each of them in turn, bar 1 or 2, which are not were not mentioned yesterday. The first contention is that most of the charges in Ms. Mazzoni's motion concern events which predated the adoption of the new rules on the 3rd of December, whereas the rules don't operate with retrospective effect. Here, it's alleged that retrospectivity would be inconsistent with the so-called rule against retrospectivity and the maxim nulla poena sine lege. Advocate Mkhwebane consequently alleges that insofar as the charges in Ms. Mazzoni's motion relate to events before that date, the motion is not in order and it's not a valid foundation for the impeachment process in relation to her. We've already dealt with the essence of this challenge when answering her contention that the new rules cannot validly apply with retrospective effect. And I suppose as reformulated yesterday, it would be the new rules do not apply retrospectively, properly interpreted. Her second contention is many of the charges in the motion concern things done or not done in the course of her investigations or things said in her reports. And this, she says, infringes the independence of the institution of the public protector, which is guaranteed by section 181(2) of the Constitution. Now, we deal with this issue in our main heads at paragraphs 200 to 205, and in our supplementary heads at paragraphs 16 to 26. And to put this contention into its proper factual context, we point out that the charges that Ms. Mazzoni has levelled against Advocate Mkhwebane are based, amongst other things, the findings of the Constitutional Court in the litigation instituted against her by the South African Reserve Bank, which include findings in relation to things done by her in the course of her investigation into the CIEX matter and things said by her in the resulting CIEX report. And secondly, they are also based on the findings of the High Court in a matter brought to her against her by the DA, which include findings in relation to things done and not done by her in the course of her investigation into the Vrede dairy matter. Our submission is this: if following a section 194 inquiry and a consideration of the evidence, the section 194 committee reaches the same or similar conclusions to those which the courts did, a legitimate outcome may be a finding by the committee that Advocate Mkhwebane misconducted herself or is incompetent within the meaning of those terms as defined in the new rules. We further submit it would be absurd and incompatible with the purpose and function of section 194, which, as I've already said, is the ultimate accountability mechanism provided by Chapter 9, if the public protector's actions or omissions in the course of her investigations or things said by her in her reports were impermissible bases for a decision by the Assembly that she be removed from office. Now, these submissions are illustrated by the facts giving rise to and the findings and orders in the matter of Minister and Police versus Vulwana and another, 2019, Volume 4, SA 297, Eastern Cape Mthatha, to page 837 of the bundle. And we emphasize that this is a case relied on by the public protector in her written argument. As the court will recall, in that case, a magistrate, who was the first respondent, had allowed an attorney, the second respondent, who had appeared for one of the parties in the case before him, to rewrite a draft of his judgment, unbeknownst to the other, to the losing party. The rewritten judgment contained significant amendments and additions. The magistrate then adopted the rewritten judgment as his own and signed it. The losing party didn't find out about all this until several months later, when the winning party's attorney sought to enforce the payment the magistrate had ordered the losing party to make. In review proceedings brought by the losing party, the High Court found that the magistrate had misconducted himself, had engaged in improper conduct, had been dishonest, and had abdicated his judicial office and thus put the judiciary as an institution into disrepute. Now, we submit that if the judicial officer in that case had been a judge, it would have been competent and proper for the Judicial Service Commission to consider the papers in that matter and the judgment in the High Court, and to decide in terms of section 177(1)(a) of the Constitution that the judge was guilty of gross misconduct, and for the National Assembly then to adopt a resolution calling for the judge's removal from office in terms of section 177(1)(b) of the Constitution. And why we emphasize that is that the judgment of the magistrate in that case is the same as the report of the public protector. It stands on the same footing. It's something done in the course and scope of the exercise of the powers and responsibilities that they have as a judicial officer or as a Chapter 9 office bearer. So returning then to the Speaker's decision that Ms. Mazzoni's motion is in order. None of the charges of misconduct and incompetence in the motion, based on the papers and judgments in the proceedings for judicial review of reports of Advocate Mkhwebane, is based merely on the incorrectness of the findings in those reports. The charges relate to her actions and conduct in relation to the relevant investigations and report, and, I would add, in relation to the litigation which ensued about them. The charges allege her actions and conduct constitute misconduct or are evidence that she is incompetent. And I don't have time to do so today, but I refer the court to Annexure TRM 60. It's in volume 60 at pages 540 to 550. That is the motion on page 560, and then the annexure to the motion, which sets out the various charges in question. Her third contention, which was not persisted in yesterday in oral argument, is that many of the charges in the motion are based on the findings of judges in litigation concerning her, whereas the National Assembly must decide for itself whether she's misconducted herself or is incompetent. I don't intend dealing with that. It's addressed in paragraphs 152 to 158 of our note, and we stand by that. At para 159, we then deal with the fourth contention, and that's the Assembly is precluded by the rule against double jeopardy from impeaching her on the basis of conduct mentioned in Ms. Mazzoni's motion, for which she's already been punished by the courts when imposing punitive and personal costs orders. Now, we deal with this issue in our main heads of argument at paragraphs 212 to 214, and in our supplementary heads at paragraphs 39 to 42. We point out that this argument was raised by her at the hearing of Part A, and that the court, in dismissing the Part A application, stated with respect correctly the following in relation to this argument in paragraph 106 of its judgment. Other than in the context of criminal proceedings, there is certainly no principle of double jeopardy of general application, as she contends. She need look no further than the very remedial action that she herself orders. Now, the rule against double jeopardy is one of our criminal law, and it's now entrenched in section 35(3)(m) of the Constitution, which provides that every accused person's right to a fair trial includes the right, and I quote, not to be tried for an offence in respect of an act or omission for which that person has previously either been acquitted or convicted. And we know that section 106(1) of the Criminal Procedure Act consequently makes provision for pleas of that kind. In State versus Basson 2005, 1 SA 171 Constitutional Court at para 64, the court commented on the defence of double jeopardy with specific reference to section 35(3)(m) of the Constitution. The majority held that, and I quote, for the plea to be sustained, the accused must show that he or she was in jeopardy of conviction in the first prosecution. An accused will have been in jeopardy if the previous court had jurisdiction to try him or her. The trial was based on a charge on which a conviction could have been obtained, and the acquittal was on the merits. Now, section 35(3)(m) of the Constitution does not avail Advocate Mkhwebane. And the reason is that none of the cases for judicial review of her reports put up by Ms. Mazzoni MP in support of the motion for her removal was a criminal matter. The costs orders made against her in those matters were not punishments for criminal offences committed by her. And the present impeachment proceedings are not criminal proceedings either. In any event, and assuming without conceding that the rule against double jeopardy operates outside criminal proceedings, none of the judgments relied upon by Ms. Mazzoni were proceedings for the removal of Advocate Mkhwebane as the public protector, or findings as to her fitness to occupy the office for purposes of section 194 of the Constitution. She was therefore never in jeopardy of being removed from office or found to have committed misconduct or be incompetent as envisaged in section 194 in any of those proceedings. That there was no threat of the public protector being competently removed by a court is evidenced by Institute for Accountability at page 274 of the bundle, in which the applicants sought the removal of the public protector. The court will recall that Coppin J dismissed the application as it would have violated the principle of the separation of powers for a court to order the removal of the public protector. Thus, there could not have been a credible threat of her being removed by any of the courts in which her reports were being challenged. We point out that her argument, if correct, would mean, for example, that an incumbent of a Chapter 9 office convicted by a court of a crime could not also be impeached in terms of Section 194 on account of the misconduct which resulted in the conviction. We submit that the imposition of a criminal sanction on the incumbent of a Chapter 9 office does not denude the Assembly of its original constitutional function and power to remove the incumbent from office in the circumstances and the manner postulated in Section 194. That then brings me to her fifth contention, and that is that the Speaker failed to assess the substantive requirements of Ms. Mazzoni's motion and to perform the requisite prima facie assessment, as she calls it. The underlying argument, as the court will know, is that Rule 129S requires the Speaker to evaluate the strength of the evidence supporting and attached to the motion. The argument is incorrect for the reasons set out in our heads at paragraph 170. Essentially, the task that the Speaker had to perform under 129S was to assess the motion against the form and content requirements of 129R. That's the first job. Secondly, to consider whether it was consistent with the Constitution, the law, and the new rules. And thirdly, and this is the important part for present purposes, to determine whether prima facie, on the face of the motion, the charges of misconduct, if established by the evidence, will constitute misconduct as defined by the Assembly and the new rules, and whether the charges of incompetence, if established by the evidence, will constitute incompetence as so defined. In contrast, the task of the panel was to assess whether there is prima facie evidence, and we emphasize the word evidence in that phrase, to show that the incumbent has committed the misconduct or is incompetent or is incapacitated for the reasons alleged in the motion. We submit the rules cannot sensibly be interpreted to confer essentially the same functions on the Speaker under Rule 129S and the independent panel under Rule 129X1B. In oral argument yesterday, this was with regard to a document which my learned friend referred to as the confession letter. Counsel for Advocate Mkhwebane criticised the Speaker's letter of 30 January 2020. It's annexure TRM 46, volume 6 at page 502, saying, if we understood him correctly, that it did not contain adequate reasons for her decision on 25 January 2020 that Ms. Mazzoni's first motion is in order. We submit the criticism is unfounded. Though relatively brief, the relevant part of the letter does explain the Speaker's decision. It says that Ms. Mazzoni's motion complied with the form requirements of the rules, and the independent panel would make the required prima facie assessment. And read in its context, that obviously means the assessment of whether there is prima facie evidence to show the incumbent was incompetent for the reasons alleged in the motion, or had misconducted herself. At that stage, there wasn't such a charge. But we do emphasize at this point, and the heavy reliance placed on this letter is totally irrelevant to the determination of the relief before the court. And the reason is, on the 21st of February 2021, Ms. Mazzoni withdrew the motion to which the letter relates, the first motions. She replaced it with a second one, and it's common cause that is the operative motion. It has at best peripheral relevance to the issue of costs, the punitive costs order which is being sought, but it certainly has no bearing on the review sought of the Speaker's finding that this motion, the second motion, was in order. The Speaker's answering affidavit, on the other hand, shows that on the 26th of February, she carefully considered Ms. Mazzoni's second motion and was satisfied that it conformed with Rule 129R. Now, time doesn't permit me to take the court to the Speaker's answering affidavit, volume 4, at pages 242 to 244, paragraph 125 with its subparagraphs, but I do commend that to the court, and I ask that it be read with the motion itself and the charges, which, as I've indicated, is annexure TRM 60, volume 6, pages 540 to 550. The Speaker gave detailed reasons in her affidavit for the finding that the motion was in order. The sixth contention that was raised is that the Speaker wrongly decided that there was prima facie evidence of intention in the form of dolus. Now, that wasn't pressed in argument, so I'll say nothing more about it now. Her seventh contention is the Speaker's decision to continue with the impeachment process initiated by Ms. Mazzone, while the current challenge to the validity of the new rules was pending, was grossly unreasonable. Now, we deal with this allegation, which we have to say is baseless, in our heads of argument at paragraph 248. In fact, it reflects badly on the public protector that she could make this allegation in the light of the outcome of the proceedings for relief in Part A, in which her application for an interim interdict was dismissed with costs. My learned friend is quite correct that after failing to get leave to appeal from the full court, she sought the Constitutional Court's leave to appeal directly to it, and that leave was refused on the basis that direct access would not be appropriate. She never sought leave from the SCA to appeal to it, and so consequently the full court's judgment has become final and is binding on her. And I reiterate, it is unfortunate, regrettable, that she should seek to raise this argument in the light of the outcome of that case. Hence our submission that it's a baseless allegation. One takes a step back and looks at the facts. In refusing to accede to her demands that the impeachment process initiated by the tabling of Ms. Mazzone's motion be stalled, the Speaker has acted as required by the Constitution and the rules. And that goes to the constitutional importance of the process which is unfolding in Parliament. It was recognised by the full court in its judgment on Part A, where when considering the prejudice to be suffered if the Assembly were to be interdicted from proceeding with the Section 19 process, it stated in paragraph 115 the following: "It's apparent that the applicant completely lost sight of the responsibilities of the National Assembly in carrying out its constitutional mandate in holding the applicant to account through the provisions of Section 194 and the processes under the new rules. Moreover, the applicant fails to take into account the public interest in ensuring that the proceedings under the new rules are proceeded with in the light of the serious charges which have been preferred against the applicant." And it's in that connection that I just wish to add something which is not in the note as regards the principle of separation of powers. Our submission is that that principle requires this court to respect the fact that the Assembly is constitutionally empowered and indeed obliged to determine the fitness of a Chapter 9 office bearer against whom charges have been levelled by a member, which, if established by the evidence, will constitute impeachable misconduct or incompetence. Finally, Justice Presiding, I come to her contention that the Speaker should have given her prior notice and an opportunity to be heard before deciding that the motion was in order. I promised I would address this question. For two main reasons, we submit the contention is unfounded. The first is that Advocate Mkhwebane, like the incumbent of any other Chapter 9 office whose impeachment is sought, has no right to prior notice and an opportunity to be heard before the Speaker takes a decision on whether or not a motion for the impeachment is in order. The reasons are the following. Although Section 3 of PADGA confers a right to ARDI for administrative action which adversely affects a person's rights or legitimate expectations, the Speaker's decision that a motion in order is not administrative action subject to PADGA. Moreover, and in any event, a decision that a motion is in order does not adversely affect the rights or legitimate expectations of a Chapter 9 office bearer. And that is, of course, a reference to the trigger for ARDI in Section 3.1 of PADGA. So even if PADGA did apply, it would not be one which materially affect her rights or legitimate expectations. And then, of course, there's the point which the DA has explained in its heads of arguments at paragraph 40 at pages 19 to 23, that in our law, this is the overwhelming authority is that there is no right to a hearing before a decision is taken to refer a complaint for investigation, during which, in other words, during which investigation the respondent will be heard. Finally, we submit there's no requirement in the Constitution, in any other law or in the NA rules that ID be given to the office bearer before the taking of a decision that a motion is in order. Nor does procedural rationality require that, because the speaker can perform her preliminary screening task under the rules by having regard to the motion and, if necessary, consulting with the member who has submitted the motion. And all of this is demonstrated by the fact that the rules do provide the office bearer with a fair opportunity to address the charges against them at an early stage in the process. And it can do so again if it proceeds with an inquiry under 194(1)(b). That's obviously in the committee, but I would emphasize the early stage opportunity. Rule 129(x)(1)(c)(2) requires that the independent panel, once established, and here's the key, must, without delay, provide the office bearer with copies of all information available to the panel relating to the assessment. It will include the motion and the evidence attached to it, and then the panel must provide the office bearer with a reasonable opportunity to respond in writing to all the relevant allegations against them. And as I've already submitted earlier when dealing with these rules, her response could be, but this motion doesn't fit the bill. The allegations of misconduct, even if proved, are not misconduct such as is defined, or incompetence as is defined, or the evidence isn't attached, or whatever the case may be. There's no restriction on what the office bearer can say at that stage, and her views will be taken into account. And the panel, of course, needs to reach a finding and make recommendations which are then placed before the Assembly so that it in turn can exercise the power conferred on it to decide whether or not the matter should proceed as far as the Section 194(1)(b) committee. Her ninth and final attack against the Speaker's decision is that she's biased, as evidenced by her unnecessarily taking sides in the dispute between the President and her in the litigation about the Basasa report. And further, that because of her participation in that litigation, the Speaker should have recused herself from managing the impeachment process consequent upon Ms. Mazzoni's motions. Now we yes, Melanie. I didn't hear you, milady.
1 o'clock.
Would you like to take the adjournment? I'm indebted to you and very grateful. I too would like to take the adjournment.
Adjournment at this stage, the court will there will again be somebody to lead the council in the court at 1:20. The court is adjourned until 12. Then we might proceed with the breaking up. Let's just recap. You have an hour.
That's correct, Malay. Thank you. I was about to deal with the applicant's ninth and last attack on the Speaker's decision to the Speaker's decision that Ms. Mazzoni's motion was in order. And it is that the Speaker is biased against her, as evidenced by the Speaker unnecessarily taking sides in the dispute between the President and her in the litigation about her Bosasa report. And further, that because of her participation in that litigation, the Speaker should have recused herself from managing the impeachment processes consequent upon Ms. Mazzoni's motions. That is the contention. What I would like to do is to start, instead of referring to our heads, just to take the court very briefly to the papers. May I ask the court to turn to volume 3, which is the Speaker's answering affidavit, page 238 as I have it, which is the place where this is first dealt with in paragraph 115. The paragraph 115 reads, on the 17th of February 2020, the President, who is the second respondent in the current proceedings and is abiding the decision of this Honourable Court, delivered an explanatory affidavit in which he referred to an application he had instituted against the Public Protector in the Gauteng Division of the High Court Pretoria under case number 5578 of 2019 for judicial review of her report number 37 of 2019-2020, which was issued on the 19th of July 2019 and entitled Report on an Investigation into Allegations of a Violation of the Executive Ethics Code through an Improper Relationship between the President and African Global Operations, AGO, formerly known as BUSASA. Speaker then says, it bears mentioning that although I was cited as the second respondent in that matter, in my capacity as Speaker, I applied for and was granted admission as the second applicant because I too seek judicial review of that report, though only insofar as it concerns the Speaker and the constitutional mandate of the National Assembly. I shall deal with the grounds on which I seek the relief later in the affidavit. Returning to the President's affidavit, the Speaker says, he said that because he was involved in that litigation, he accepted that a potential conflict of interest had arisen, and he may be called upon to suspend the Public Protector under Section 1943 of the Constitution while the litigation, that's the Bosasa litigation, is still pending. The matter was argued on 4 and 5 February 2020 and judgment was reserved. The Speaker's affidavit, as the court will know, was made on the 3rd of March 2020. Accordingly, he said, if the need for him to consider whether or not to exercise the power of suspension were to arise, he would delegate exercise of the power under Section 1943 of the Constitution to another member of the Cabinet who does not have a similar conflict of interest. And then if I could ask the court to turn to page 282, which is where paragraph 213 should be found. Here's the Speaker's answer to this allegation. Turning to Advocate Nkwebani's allegation that I and the Deputy Speaker have unnecessarily decided to take sides in the dispute between the President and her in the litigation about the Bosasa report referred to in paragraph 115 above, by siding with the President against her instead of maintaining our independence. I deny that we took sides unnecessarily. I applied to intervene as a co-applicant in that matter because, in my estimation, certain of the remedial action and monitoring measures, namely those contained in paragraphs 8.1.1, 8.1.2, 8.1.3, 9.1, 9.2 and 9.3 of the report, amounted to impermissible prescriptions to the National Assembly about the manner in which it exercises oversight over the executive, were incompatible with the Ethics Code, that's the Parliamentary Ethics Code, which does not apply to the President, and the Executive Ethics Code, infringed the doctrine of separation of powers, and impermissibly extended to subjecting the National Assembly to monitoring by the Public Protector. In this regard, I attach marked TRM 72, a cancel of my copies written submissions to the High Court. I submit my intervention was quite proper, aimed as it was at upholding the integrity and constitutional autonomy of Parliament. The rest of that paragraph is not presently relevant. The reason I've taken the court to the passages in the affidavit are to explain what the litigation was about and, in particular, why the Speaker intervened. As mentioned in our note in para 185, the Speaker's reason for participating in the Bosasa litigation has been explained. The reference is given to 115 there. May I ask the court just to add a reference in to paragraph 213 at page 282, which is the other paragraph to which I've just taken the court. And then our submission is this: the material difference in the substantive positions of the President and the Speaker in that litigation is that he is seeking an order addressing a finding that his behaviour was improper, whereas the Speaker's involvement has nothing to do with her behaviour or personal circumstances, but rather with the public protector's remedial action being inappropriate and inconsistent with sections 182(1)(c) of the Constitution, because it impacts inappropriately, the Speaker believes, on the constitutional sphere of Parliament. The President and the Speaker are thus in materially different position, and there's no reasonable basis for perceiving the Speaker's involvement in the Bosasa litigation as evidence of bias against the public protector. That then brings me to her claim for personal and punitive costs against the Speaker. As the court knows, she claims that costs should be awarded on a punitive scale against the Speaker. And in addition, that the Speaker personally should pay 20% of such costs on the grounds that she has acted in bad faith, recklessly, and grossly negligently. In what follows, after briefly explaining the applicable legal principles, we shall address in turn each of the 9 main reasons or factors on which she relies. In the case concerning the personal and punitive costs order made against her in the Reserve Bank matter, at paragraph 223, referring to Orr versus Solomon, 1907 TS 281, that's a judgment of Innis CJ, the majority of the Constitutional Court said, and I quote, "More than 100 years ago, Innis CJ stated the principle that costs on an attorney and client scale are awarded when a court wishes to mark its disapproval of the conduct of a litigant. Since then, this principle has been endorsed and applied in a long line of cases and remains applicable. Over the years, courts have awarded costs on an attorney and client scale to mark their disapproval of fraudulent, dishonest, or mala fides, bad faith conduct, vexatious conduct, and conduct that amounts to an abuse of the process of court." In the same case, at paragraph 221, referring to its earlier judgment in Tuze versus Bytes Technology Group SA, 2013-12 BCLR 1358 Constitutional Court at paragraphs 4 to 5 and 9, and also its judgment in Paulson and another versus Slipknot Investment 777 Pty Limited, 2015-3 SA 479 Constitutional Court at paragraph 84, the Constitutional Court added, "This court has endorsed the principle that a personal costs order may also be granted on a punitive scale. The punitive costs mechanism exists to counteract reprehensible behaviour on the part of a litigant." The test here is whether there has been fraudulent, dishonest, bad faith conduct, vexatious conduct, conduct that amounts to abuse of the process of the court, or reprehensible behaviour on the part of the Speaker. Now, as we shall demonstrate in the present matter, there is no basis to mark the Speaker's office with punitive costs, or the Speaker in her personal capacity with punitive costs. She has merely been performing her duties as required by the Constitution and the new rules, and she has done so reasonably and in good faith. That brings me then to Advocate Mkhwebani's reasons for claiming personal and punitive costs against the Speaker. First, she cites the Speaker's failure to notify her of the removal process that had been initiated by Ms. Mazzoni's motions on 2 occasions. The first was when the Speaker issued a media statement about Ms. Mazzoni's first motion on 25 January 2020. The second was when the Speaker accepted Ms. Mazzoni's second motion on the 26th of February 2020. We submit for 3 reasons this complaint is unfounded. First, Rules 129S and 129T do not provide that the Speaker should notify a Chapter 9 office bearer of a motion to initiate proceedings for a Section 194 inquiry. By contrast, Section 129X1C2 requires that the independent panel, once established, must without delay provide the office bearer with copies of all information available to the panel relating to the assessment. That will include the motion and the evidence attached to it. So in other words, the rules provide that the office bearer be notified by the independent panel and once the matter has been referred to it. Second, as regard the Speaker's media statement on the 25th of January 2020, a copy of which is annexed to TRM 44, Volume 5 at 493, and I would ask the Court to consider that. The context is that the previous day, the 24th of January 2020, after considering Ms. Mazzoni's first notice of motion, the Speaker was satisfied that it complied with the formal requirements of Rule 129R, and she consequently, firstly, announced to the Assembly her receipt of the notice of motion. Secondly, announced to the Assembly her receipt of the, the first was she announced the receipt of the motion. Second, she invited political parties to nominate by 7 February candidates for the appointment to the independent panel in terms of Rule 129V. And thirdly, she circulated a memorandum in similar terms to the chief whips of all political parties represented in the Assembly. We describe these facts in our heads, paragraph 62. Now, in her answering affidavit, paragraph 207, the Speaker gives 3 reasons why she made a public announcement at that juncture. They are the following. First, the commencement of the process aimed at the establishment of the independent panel was the first public step by the Assembly in relation to a matter of public concern. Secondly, the sending of a memorandum to the political parties meant it was bound to receive some publicity. And thirdly, she wanted to ensure that the media was able to report accurately on what was happening. And we submit that the Speaker cannot be faulted for making the announcement that she did. And perhaps it is helpful if I were to take the Court to the announcement. May I ask you to turn to Volume 5, page 493, TRM 5. I just need to check the reference if you don't mind. I'm just checking the reference. It appears to be, it's a reference to a minute, and I'm afraid that that's the incorrect reference. Just bear with me 1 second, please. 493.
493.
Thank you. TRM 44.
That is.
I'm indebted to you, my lady. So it reads as follows. Parliament, Tuesday, 25 February 2020. National Assembly Speaker Ms. Thando Modise has received correspondence from the Chief Whip of the Democratic Alliance, Ms. Natasha Mazzoni, advising of the, but this is the, I'm sorry, my lady, this was the wrong one. That was what I was concerned about. That's the second one. I apologize. Could I ask, I'll give the correct reference at the end of my address, and I apologize for taking you to the wrong document.
And your hours sleeping.
The third reason why complaint is unfounded, we submit, and this relates to the Speaker's acceptance of Mazzoni's second motion on the 26th of February 2020, is that when has regard to the context, it's this. The Speaker received that motion on the 21st of February, On the 25th of February, Parliament issued a media statement to the effect that Ms. Mazzoni had withdrawn her first one and replaced it with a new one, and the Speaker would apply her mind to the new motion to determine if it meets the requirements provided for in the NA rules. And thirdly, on the 26th of February 2020, the Speaker considered the second notice of motion, was satisfied that it conformed with Rule 129R, notified Chief Whips and Advocate Mkhwebane of the events of 21 February and of her decision, and provided Advocate Mkhwebane with copies of both motions. We deal that in our heads at paragraph 76 to 83. In her answering affidavit at paragraph 169, the Speaker explains why she decided on 26 February to provide Advocate Mkhwebane with copies of both Ms. Mazzoni's motions. She did so to enable Advocate Mkhwebane to take an informed decision as to whether or not she wished to carry on the present application, and if so, to supplement her founding papers. And further, given the length and relative complexity of Annexure A to Ms. Mazzoni's motion, that's pages 541 to 550 of TRM 60, to give her a longer period of time to prepare a response to the charges against her than would be the case if she received a copy of the motion from the independent panel, which the rules say must complete its work within 30 days of its appointment. Now, we submit the Speaker acted properly in dealing with these developments in the manner that she did. May I ask the court just to bear with me for a moment? My juniors are not with me. I just want to locate the first annexure and give the court the correct reference. Lady, I've discovered the reason for my error. It's that there is indeed an error in the Speaker's affidavit at paragraph 101. The reference at that juncture is to TRM 44, and what is attached there is the wrong media release. The media release of the 25th of February, not the media release of the 25th of January. I apologize for that. I suspect the correct version is attached to the applicant's founding affidavit, but I don't have that reference to hand and I don't want to detain the proceedings any longer. That brings us to the second reason for seeking a personal and punitive costs order, which concerns the fact that the Speaker did not give her an opportunity to be heard before deciding whether Ms. Mazzoni's motions were in order. But as explained earlier, she had no right to be heard before the taking of those decisions, and in any event, she had the right to be heard by the independent panel. The third reason given by Advocate Mkhwebane for the personal and punitive costs order she is seeking is the Speaker's failure to assess the substantive requirements of Ms. Mazzoni's motion and to perform the requisite prima facie assessment, as she puts it. We've responded to these contentions when dealing with her challenge to the Speaker's decision that Ms. Mazzoni's motion was in order. For the present, suffice it to say the following: the rules do not place a duty on the Speaker substantively to assess the evidence presented in a motion to determine whether prima facie it shows the holder of office has committed the misconduct alleged or is incompetent or incapacitated as alleged. That is the task for the independent. On the 26th of February, Speaker did carefully consider Ms. Mazzoni's second motion, and she was satisfied it conformed with Rule 129R. And I've already indicated that we commended the court paragraph 125 of the Speaker's answering affidavit, read with the motion, which shows that she did apply her mind seriously to that. Her fourth reason for seeking a personal and punitive costs order is the Speaker failed to provide reasons for decisions that Ms. Mazzoni's two motions were in order. That's for the Speaker's decisions, obviously. For three reasons, this complaint is unfounded. Firstly, as explained when responding to the 8th challenge to the new rules, Advocate Mkhwebane, like the incumbent of any other Chapter 9 office whose impeachment is sought, has no right to reasons for those decisions. And I've already given the reasons for that and won't repeat them. Secondly, and as already mentioned, in any event, on the 30th of January, the Speaker gave Advocate Mkhwebane brief reasons for decisions that Ms. Mazzoni's first motion was in order. saying it complied with the form requirements of the rules and no decision had been taken as to the required prima facie assessment as the independent panel appears to be established. Thirdly, and as also mentioned in her answering affidavit, which I would emphasize, the Speaker made 5 days later. The Speaker made her affidavit on the 3rd of March 2020. The Speaker gave Advocate Mkhwebane detailed reasons for her 26 February decision that Ms. Mazzoni's second motion was in order. Her fifth reason for seeking a personal and punitive costs order is a criticism of the Speaker's decision to accept Ms. Mazzoni's motions, despite the fact that the evidence on which they are based concerns her conduct before the new rules were adopted 3 December 2019. That's to say largely concerns her conduct before. But for the reasons given earlier, the rule do indeed operate retrospectively. Moreover, in any event, there was nothing unlawful, sinister, or blameworthy about this aspect of this decisions, which is fully explained in her papers. Her sixth reason for seeking a personal and punitive costs order is that the Speaker should have followed the example of the President and acknowledged the reasonable perception of bias borne out by the Speaker's own involvement in the Bosasa litigation and recused herself from managing the impeachment processes consequent upon Ms. Mazzoni's motions. But for the reasons given at the start of my address of lunch and adjournment, there's no merit in this complaint. The seventh reason she gives for seeking a personal and punitive costs order against the Speaker concerns her failure to take action against alleged breaches by members of the NA of the sub judice rule, that's Rule 89, which provides that no member may reflect on the merits of any matter on which a decision in a court of law is pending. There are 3 fundamental difficulties with this complaint. First, the events on which it are mainly based, namely the statements critical of Advocate Mkhwebane made by members during the meeting of the Portfolio Committee on 6 March 2018, and all but one of the motions by Mr. Steenhuisen calling for it, all happened during the 5th Parliament. In other words, before the 6th Parliament was constituted and the current Speaker, Ms. Madisa MP, was elected on the 20th of May 2020. So the main factual foundations of the complaint are thus deficient. Second, the complaint is legally unfounded as well. As appears from the Speaker's response in her answering affidavit at page 261, the sub judice rule does not preclude the members of the National Assembly from performing their oversight functions, or for that matter, from initiating or participating in impeachment processes. At all material time, sections 55 2B2, 185, 181.5 and 194 of the Constitution have been in operation and have authorized members of the Assembly to oversee the Public Protector, hold it to account, and seek her removal from office. Third, and most fundamentally, even if the Speaker is wrong in the interpretation of the sub judice rules, no evidence of the interpretation being reckless, grossly unreasonable, or in bad faith. Advocate Mkhwebane's 8th reason for seeking a personal and punitive cost order against the Speaker is her allegation that the Speaker has failed to recognise the reasonable views of members of the NA in respect of the handling of the litigation and the process, for example, by refusing to give the ATM a reasonable extension to allow the ATM to apply its mind to the legal issues in the Part A application before nominating to serve on the independent panel. The other example she gives is the Speaker's decision not to halt Section 190 process, pending the outcome of Part B. There are 2 main difficulties with this contention. The first concerns her first example, the second concerns her second example. The facts show that the Speaker acceded to the ATM's request and granted what is a reasonable extension. On the 24th of January, she invited the political parties represented in the Assembly to nominate appointees to the independent panel by 7 February. On the 5th of February, the ATM requested that she extend the time period. On the 7th of February, the ATM advised all chief whips that the deadline had been extended to 12 February. Second, as regards the Speaker's opposition to the relief sought by Advocate Mkhwebane in this application, the opposition to the Part A relief was found by the full court to be justified, and her opposition to the Part B relief is, we submit, reasonable and bona fide. As regards Advocate Nkwabani's criticism of the Speaker's opposition to Part A, the full court found, with respect correctly, in its judgment at paragraph 150, and I've already quoted this passage about the applicant losing sight of the responsibilities of the Assembly and the public importance of dealing with the matter, given the serious charges preferred against her. And as regards her criticism of the Speaker's opposition to Part B, she was merely defending rules adopted by the Assembly and a decision of hers to approve a motion taken with reference to the rules. As things have turned out, the Assembly supported a decision to proceed with the impeachment process, and by implication, her approval of the motion is in order when on the 16th March, it voted in favour of the establishment of a Section 194 committee. That fact appears from her affidavit of 2 June. Her ninth and final reason for seeking a punitive costs order is an allegation that on the 8th of June last year, the Speaker breached an alleged agreement or understanding between the parties and their legal representatives by unilaterally resuming the processing of Ms. Mazzoni's motion without giving prior notice to Advocate Nkwabani and the other affected parties. Now, this was not advanced yesterday in oral argument by my learned friend, and so we consequently stand by what we have said in that regard in our heads of argument and in the portions of this note from paragraphs 201 to 10. The court will by now have got a flavour of the allegations against the Speaker. The question is, I submit, not so much whether they show fraud, dishonesty, bad faith, vexatious conduct amounting to an abuse of the process of court, or reprehensible behaviour on the part of the Speaker. There is, with respect, no question of that. The real issue is whether it's appropriate for a senior officer of the state, the applicant, to level charges of this nature against someone who's merely doing their duty on such a flimsy foundation. I'll leave the court to be the judge of that. My client, the Speaker, accordingly asks for an order refusing the relief sought in Part B of the notice of motion with costs, including the costs of due counsel, payable by the Public Protector in her official capacity. And we shall give you the reference, if you can find it, to the missing media statement of the 25th of January.
Mr. Treaty, can you hear me?
I can clearly.
Okay. At the expense of something like a broken record, I want to go back to the issue of the independent panel.
Yes.
You mentioned that it is an advisory body and it has no powers to make any determination whatsoever.
Nothing binding on the Assembly yet.
Nothing binding on the Assembly, yes. Further in your submission now, you mentioned that the applicant cannot complain about not being afforded housing because you can always get it from this panel.
Correct.
What is the nature of this panel? Because now certain functions, very important functions, are now given to it to advise the applicant that this is the case against you and not the Speaker.
So the answer to that is that as the court knows, the panel, and I'm just quoting the words of 129(x)(1)(b), it must determine whether there is prima facie evidence to show that the holder of public office committed misconduct, is capacitated, or is incompetent. So it needs to make that determination. That's its job card.
That's right. But the complaint by the applicant is that I did not get to know about the complaint from the speaker. And the submission is that the complaint is unfounded because the panel in any event is going to advise you.
So the answer to that is, if one looks at the process in a streamlined, if I could describe it in a streamlined way, a member of parliament gives notice under rule 124.6, that's 129R, initiating the proceedings. The second thing that happened is that the speaker assesses the motion to determine whether or not it is in order, compliant with the criteria. That's 129S. 129T then says, when the motion is in order, the speaker must immediately refer the motion and any supporting documentation to the independent panel appointed for the assessment and inform the Assembly and the President. So the rules say she must inform two people, the Assembly and the President, and she must send it to a panel. And 129 says, 3 days of its appointment, conduct and finalize that preliminary assessment to which I've referred, 129 1B, and 1C2 must without delay provide the holder of public office with copies of all documentation available to it. So what happens is, once the speaker has assessed the motion as being in order, he must immediately refer to a panel, which must without delay provide the documentation to the holder of public office and give the holder an opportunity to respond. So the rules provide that it is the panel who notifies the public officer.
Definitely. So is it now only in terms of the description you are giving as an advisory body, or now it has a function in the process by now providing the applicant with the necessary documentation?
Undoubtedly, it has an important function, and the function is to consider the documentation, because it's all done on paper, as you know, from the provisions of 129X, to consider the response, a reasonable opportunity to respond in writing to the allegations. It may afford any member an opportunity to place written, relevant, recorded information before it, and having done all of that, it has to determine whether there's prima facie evidence to show the holder of the office has committed the misconduct, etc. And it must formulate a report, include in its report any recommendations and reasons for its recommendations. And it's because of the latter. What it does is it makes recommendations, gives reasons. And in this context, obviously, it will have to set out what the charges are, set out what the response from the office bearer is to the charges, and then give its assessment of whether there's prima facie evidence to show that the holder of office has constituted misconduct and so on. And we know that, as a matter of fact, in this case, that is what the panel did. You have as an annexure to the Speaker's affidavit, you have the last few pages of the independent panel's report. They're annexure TRM 78. And it concludes as follows, paras 256 to 261. So this is how it's operationalized. In summary, in respect of the charge of misconduct, the panel finds that there is sufficient information that constitutes prima facie evidence of misconduct. This relates, amongst others, in the SARB report to the PP's failure to reveal that she had meetings with the President and the SSA, that's the State Security Agency, and the failure to honour an agreement with the SARB, thereby displaying non-compliance with the high standard of professional ethics as required in terms of Section 195(1)A of the Constitution. Turning to another example, namely the Fred Aderi report, the PP, amongst other things, altered the final report and gave the Premier, who was implicated, the discretion to determine who the wrongdoers were. The PP removed the referral to the SIU and the AG from the final report, provided an untruthful explanation to the review court as to why this was done. And the PP failed to investigate the third complaint, in breach of her constitutional and statutory duties and functions in sections 182 of the Constitution and section 7 of the Public Protector Act. Additionally, the PP patently made a wrong finding on money laundering in the CR17 matter and doubted the bona fides of the President without reason. In our view, this information regarding the conduct of the PP also constitutes prima facie evidence of incompetence. Recommendations. In the circumstances and for the reasons contained in this report, we recommend that the charges of incompetence be referred to committee of the Assembly as provided for in the NA rule, and in the circumstances as provided for and for the reasons contained in this report, we recommend that the charges of misconduct be referred to committee of the Assembly as provided for in the NA. As an advisory body making a recommendation substantiated by reasons I was reading from page 115 of the report, which the Assembly duly considered and decided that the matter should proceed further.
Thank you.
Thank you, Mr. Rekenbach.
Indebted to you, lady.
Thank you. Mr. Lady.
Thank you, Justices. I'll make some very brief submissions on behalf of the President. Can I just inquire, is the court able to hear me?
Yes.
Thank you. Thank you very much. Thank you. Justices, the case against the President, perhaps let me start by saying this. The President plays a very limited role in this litigation. He has to date filed 2 explanatory affidavits in the matter, the first of which relates to the relief sought in Part A, and the second of which relates to the Part B application. No relief has been sought against the President in Part B of this application, but despite that, certain averments have been made on the affidavits filed, and these submissions are directed specifically at those averments and specifically at any order that this court may be inclined to make or refer to those allegations in its judgment. So with that in mind, Justices, there are really only 6 very brief points that I intend canvassing. The first of them, Justices, is the case that has been made out in the amended notice of motion. My learned friend, Mr. Mpofu, referred the court to the amended notice of motion this morning. It appears at volume 10, page 977. And as the court will be aware, relief sought in the amended notice of motion is directed in the first instance at an attack on the content of the rules. In the second instance, it is directed on the adoption of the rules themselves. And in the third instance, it is directed at certain decisions which the Speaker took pursuant to the rules. And so I make the obvious point, Justices, and that is that none of the orders sought in the amended notice of motion either directly or otherwise implicate the President in this litigation. That notwithstanding, there have been averments made in the supplementary affidavit, supplementary founding affidavit, which I'll deal with briefly. The second of my 6 points, Justices, is just to set out clearly the President's position in relation to this litigation. It appears in the President's explanatory affidavit. The court needn't go there, but it's at volume 13, page 1321, and paragraph 17 in particular. And the court will be aware from the averments that the President has made that his overall position is to say that insofar as litigation remains pending between him and the Public Protector, he will not take any decision in terms of section 194.3 while the pending litigation remains alive. Justices, you will be aware that the Bosasa litigation was argued in the Constitutional Court on the 26th of November last year, and that judgment has been reserved. It hasn't been delivered as yet. And so in light of that, the President says that he will not knowingly flout the Constitution. He's cognizant of his duties under Section 96 2B of the Constitution, and that he will take no steps before the Constitutional Court hands down judgment in the matter. The third point, Justices, is perhaps just to emphasize the stance that our learned friends for the Public Protector take in their heads of argument. And once again, you needn't go there, but if I could perhaps give the court the reference, it's page 1512 at paragraphs 107 and 108, where they say that the President's stance in this litigation in light of the Bosasa case is both correct and commendable. But then they say in the preceding paragraph, Justices, that personal bias may include other persons who may be under investigation or who may be involved in adversarial litigation as against the Public Protector. In light of that, and just for the avoidance of there being any doubt as to the President's position and what the evidence reflects in these in this matter, Justices, that brings me to the fourth point, and that is the allegations that have been made in the supplementary founding affidavit in relation to the President. And they broadly fall into two categories, Justices. The first of which is what we've termed to have been a factually inaccurate allegation. And if I can draw the court's attention to what's been said at paragraph 106 of the supplementary founding affidavit, it appears at volume 10, page 959. And there the suggestion is made, or the contention is advanced, that the President's continued participation in the removal of the Public Protector irretrievably taints the entire process with actual bias and or a reasonable apprehension thereof. Justices, you will be aware that that allegation is explicitly denied by the President, and the denial appears at volume 13, page 1325. And importantly there, the President says at paragraph 29.1, I'm not involved in and have not participated in a process to remove the current incumbent of the office of the Public Protector. And then he proceeds, Justices, at paragraph 30 to say there's no basis for the Public Protector to allege bias, actual or a reasonable apprehension based on my continued participation in the process. And I invite the Public Protector to clarify in reply the factual basis for the statement, alternatively to withdraw the allegation insofar as it relates to me. Importantly, Justices, you'll note from the replying affidavit that was filed on behalf of the Public Protector, the allegation was neither justified on a factual premise, and nor was it withdrawn. In light of that, Justices, we say that there's no factual basis for these allegations and they fall to be disregarded. The second contention advanced by the Public Protector in her supplementary founding affidavit is that the President's undertaking does not go far enough because it does not cater for the potential for bias based on vengeance, which the Public Protector contends doesn't evaporate once judgment has been handed down in the matter. And for that submission to Justices, we say there's no factual basis for it. The President's raised in his affidavit a number of issues in response to it. He says in the first instance that the justification for him drawing a distinction between pending litigation and completed litigation is because if he is to act in the course of pending litigation, it carries with it a risk that his actions can bring an end to the litigation. And he doesn't believe that that's proper or appropriate. So it's got nothing to do with arguments around vengeance. It's got to do with not compromising the integrity of the litigation process that's unfair. The second issue, Justices, is that the President has said in his affidavit that it's not sufficient to allege conflict of interest or bias in abstract terms. The public protector must provide the factual basis for it. She hasn't done so, and it hasn't been dealt with in reply. Thirdly, the President says where he successfully litigated against the public protector, he certainly can't conceive of any conflict. And he says where he fails in his litigation, he'll continue to act in accordance with principles of legality and lawfulness, and there's no basis to prevent him from carrying out a constitutional function in those circumstances. So, Justices, for all of those reasons, we say that there is no merit to the public protector's stance that the President cannot exercise these constitutionally enshrined powers forever and a day. We accept that on the facts of this matter, it's something that presents itself insofar as the litigation is pending or judgment remains reserved by the Constitutional Court, but nothing further. The fifth of the six points I intend addressing, Justices, is the contention that because the President adopted this stance in relation to the public protector's removal process, it is indicative that there really is actual bias or a reasonable apprehension. And we say only two things in response to that contention. We deal with it in our heads of argument at page 1642, Justices. We say in the first instance, the President's stance in this matter is informed by the facts as they presently apply, as between him and the public protector. Nothing beyond that. And secondly, we've referred the court to the authorities around an objective determination of a reasonable apprehension of bias. And for those reasons, we say that the President's stance in this matter on these facts has no bearing in relation to other role players. Justices, the last of the 6 points I intend addressing, and that is the question of, well, what then is the import of the allegations as made by the public protector? We say they have no bearing on the relief as sought, and we say in any event, the matters governed by section 96 sub 2 of the Constitution, which deals with issues of conflict in relation to members of cabinet. Secondly, we say the factual averments have not been vindicated based on the portions of the record that I've referred the court to. And as regards the substantive relief sought in this application, we say that the President abides those orders. The President seeks no costs in relation to this application, and he submits that no costs order falls to be made as against him. Justices, unless there are any questions, those are my submissions.
There are no questions. Thank you.
Thank you. I'm indebted to the court.
We have the last speaker for the day. You've got an extra 15 minutes. Don't feel comfortable to use. Just
I feel like I've won the lottery, Justice Bastman, given the context. So yes, thank you very much. Good afternoon, members of the court, my lady and my lords. Justices, at the outset, I have prepared a much shorter note than my learned friend, Mr. Breitenbach. Could I ask my attorney to hand it to you? I have arranged for copies in court and for copies for my learned friends in court, and I'm now going to hit send on the oral on the Word document so that everybody else has it.
Yes, yes.
Thank you. I presume that the bench has it, and I presume my learned friends have it as well. I see Mr. Mpofu has it. Thank you.
Everybody has it. Thank you very much.
Thank you so much, my lady. My lady, before I delve into the note, it's necessary to take a step back for a moment, because there is a risk in this case of losing the wood for the trees. This case occurs against the following backdrop, my lady and my lords. It occurs against the backdrop where what has been said about the present incumbent in the Public Protector's office is that she acted in bad faith and in a grossly unreasonable manner, that she was not honest, and that her conduct falls far short of the high standards required of her office. That's not my client saying that, my lady. That is the Constitutional Court. It is, as far as I can recall, it is the most damning statement the Constitutional Court has ever made about a public official. That was followed, my lady, by the statement from the High Court. That was in the Reserve Bank matter. It was followed by the statement in the Vrede Dairy matter, where the High Court held that her conduct had been far worse and more lamentable than that set out in the Reserve Bank matter, and that her conduct during the entire investigation constitutes gross negligence. And both the Constitutional Court and the Supreme Court of Appeal ultimately refused leave to appeal against that judgment. Now, my lady, I'm making those points not because I expect that this court can or should pronounce on whether the public protector is guilty of gross misconduct. That's not the point. And I agree with my learned friend, Mr. Mpofu, that that is not for this court to decide. But what is for this court to decide is when it comes to interpreting the rules, and when it comes to assessing their constitutionality, and when it comes to determining what remedy, if any, to grant the public protector, what are the effects of this court's judgment going to be? Are they going to enable a proper hearing before the National Assembly and its committee, and enable the public protector to defend herself, as she's entitled to do, and enable Parliament to exercise its constitutional function? Or, as we say, the arguments of the public protector would demand, is it going to prevent Parliament from doing so? Prevent Parliament from fulfilling its constitutional function and prevent the public protector from having a chance to defend herself? And what I'm going to submit to your ladyship and your lordship is that that is a fundamental matter when it comes to the question of remedy, if there is to be any remedy, and when it comes to the level of interpretation. And it's important with respect that we don't lose sight of that. So against that backdrop, I propose, my lady, to deal with the following issues in turn. I've listened carefully, and I don't want to repeat the arguments advanced by my learned friend, Mr. Breitenbach, and we have filed very full heads as well, and I know they've been read by the court. So I propose to deal with the following issues. Firstly, the question of the proper approach to this case. Secondly, the question of the role of the panel, including the concern importantly raised by Justice Dalama. Thirdly, the question of retrospectivity. Fourthly, the question of legal representation. And fifthly, the question of fairness, particularly that raised by Justice Bartman presiding. Could I deal with each of them in turn, if I may? And that is the sequence in which the note goes. And then I will say a word about costs. But I begin, my lady, with the proper approach. And we have set out in our heads in the section that runs from pages 7 through to 17, we have set out the proper approach in a case like this. And there are certain principles which we have explained, and they have not been taken issue with by the public protector. So I'm now at page 1 of the note, paragraph 3. We say the following principles apply.
First, and all of the authorities, let me say, are in our heads, but I'm just trying to summarize them for the convenience of the court. The first is that a court is required to interpret the rules in a manner that renders them consistent with the Constitution, if possible, not inconsistent with the Constitution. Now, I know that that is trite, and I know this bench knows that, and I apologize for belaboring it. But with respect, some of the arguments advanced by my learned friend, Mr. Mpofu, appear to lose sight of that, because what you get is the most extreme or the most rigid or the most radical interpretation. And then it is said, well, therefore the rule is unconstitutional. But that is not the way it works with respect. It's quite clear from case after case after case, which we've cited, that you have to start by seeking to interpret the rules in a manner that is consistent with the Constitution, rather than declare them invalid. The second principle is that the court has to approach the matter in a manner that promotes rather than undermines the principle of accountability. Now, we know that the principle of accountability is one of our founding values of the Constitution, my lady. And we know that in whatever it does, in interpretation, in remedy, in the orders it gives, the court must seek to promote that value. And that's important, and I'll come back to it in due course. The third is that the court is required to approach the matter with due deference to the separation of powers entrenched in the Constitution, meaning that you've got to give, with respect to Parliament, some due deference. Now, Mr. Mpofu quite fairly summarized that. What he said is, it is not beyond the bounds of this court to strike down the rules. That is the function of the court, and it doesn't breach the separation of powers. And with respect, I agree with him. And then he said where the separation of powers does come in is that the court must pay some sort of deference to the calls or the judgment calls that Parliament has made on its rules. And again, with respect, he's quite right, and it's a fair proposition that he's advanced. But let's just talk about what that means for a moment, if I may. What it means is that the fact that this court thinks that the mechanism put in place via the rules is unwise or undesirable, or that there's a better way of doing it, doesn't render it invalid. And let me give a couple of examples. It's clear with respect, Justice Bartman, that you have a concern with which one could readily understand about whether it was desirable to have a judge head the independent panel. And that, with respect, is a legitimate concern. But that concern doesn't translate into irrationality, and it doesn't translate into unconstitutionality, and it doesn't translate into a breach of judicial independence. It just means that if you, Justice Bartman, had been devising the rules, you would have done them differently, and perhaps you would have done a better job, let me say. But that's not the test. The test is not whether Parliament got it perfect. It's not whether the bench would do it differently. It's whether the Parliament acted unconstitutionally. Similarly, Justice Dolamo clearly has a concern about the panel system. And again, one can understand the concern, and I'll come back to it. But the fact that Justice Dolamo has a concern about the panel system doesn't render it unconstitutional. It doesn't mean there's a breach of the separation of powers, and it doesn't mean that it's unlawful. It's the old story. Where we are dealing with whether something is unconstitutional, that is a different question from whether something is wise, desirable, or the best system. That's not the test, and there is no authority. On the contrary, the very notion of deference to Parliament about its own procedures means that absent a patent illegality, this court will not intervene. And so I'll come back in a moment to why the concerns need not detain the court. But even if the concerns persist, even if you leave today or tomorrow thinking this really was an unwise thing to do, that is not the test with respect. And it is not a basis for striking down the rules. And it would be, and I hate using it because it's an overloaded term, but it would be classic judicial overreach if that were a basis upon which to do it. The fourth principle is that the court cannot assume that the powers conferred by the rules will be abused, that they will not be properly exercised. Instead, as the authorities we point to make clear, the court has to assume the opposite. Case after case says, where Parliament or anybody confers a discretionary power on someone, and that power is challenged, the court must assume that the power will be properly and fairly exercised, that it will not be abused. And I'll come back to that when I deal with Van Rooyen. But in the Van Rooyen case, again and again, Justice Chaskelson makes that point. And so you may legitimately have concerns about what the parliamentary committee is going to do when they get there. You may have concerns about what the National Assembly may do, but that's not, again, not the test. You are required by principles which we've laid out in our heads and which our learned friend has not taken issue with. You are required to assume that the powers will be properly exercised, fairly exercised, and not abused. And the difficulty we have with our learned friend's argument is that although they have not taken issue with any of these four principles, their argument appears to ignore them. And that is a fatal difficulty with the contentions. An even more fatal difficulty is the one that we deal with at paragraph 4 of the note, and that is the question of remedy. And you touched on it earlier this morning, Justice Bartman. When the question was raised with our learned friend, Mr. Mpofu, suppose we're with you on a particular challenge, what is the remedy? Should we strike down that provision? He candidly gave an answer. And the answer was, no, you've got to strike down the rules in their entirety. Now, with great respect, that is simply wrong. It is wrong at the level of constitutional text. It is wrong at the level of jurisprudence. And it is wrong at the level of principle. And I invite my learned friend to point you to a single case in which that is what the court has done, where the court has found a defect in a piece of legislation or a set of rules, and it has proceeded to strike down the entire set of rules that have been enacted. There is no such case of which I'm aware. And the reason, Justice Bartman, is because of what section 172(1)(a) of the Constitution says, and I've quoted it in paragraph 4.1 of the note. I see there are two 4.1s, but let's not worry about that. What it says is, 172(1)(a) of the Constitution says, when a court is deciding a constitutional matter, a court must declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency. And what that means is that if one is dealing with a statute that has 20 sections in it, and one section produces a problem because it deprives you of legal representation, or because it puts in place an invalid panel, or because it does any of those things that have been complained of, you don't strike down the whole rule, all of the rules. You don't sometimes even strike down an individual rule. You strike down as narrowly as possible. And you don't, in other words, throw the baby out with the bathwater. You fix the constitutional defect as surgically and as narrowly as you can. And I'm going to come back to that in a moment. And that much, Justice Bartman, is utterly trite. And can I point you to a case which is really quite apposite and which did exactly that? It's the Van Rooyen judgment, which we've referred to in the heads of argument, but which I have quoted for you at paragraph 5 of the note. Now, could I just remind the bench what Van Rooyen was about and why it's so apposite? Van Rooyen was an independence case. It was a case about removal, in part, of public officials. They weren't judges. They weren't the public protector. They were magistrates. And what had happened in Van Rooyen is that the High Court, Judge Southwood, had proceeded to adopt a very, I say this with respect, aggressive approach, striking down left, right, and center. He struck down a regulation here, sections of an act there, conduct of the minister elsewhere. And the Constitutional Court politely but emphatically told him that he got it wrong. He got it wrong not just in the conclusion he reached, but he got it wrong with his approach. And that appears from the passages I've quoted, which starts with a heading, and it's a unanimous Concord judgment, the correct approach to constitutional adjudication. And if you wouldn't mind, I will read it because it is important. In dealing with legislation that was the subject matter of constitutional challenge, just let me pause there, nothing turns on whether they're regs, rules, or legislation. But in dealing with legislation that was the subject matter of the constitutional challenge, the High Court appears not to have had regard to two important considerations. First, that decisions of the Magistrates' Commission and the Minister in giving effect to the powers vested in them by the legislation are subject to constitutional control. If they take decisions or conduct themselves in a manner inconsistent with judicial independence or with the right that everyone has to administrative action, such decisions or conduct will be invalid and will be set aside by the higher judiciary. The well-informed, thoughtful, and objective observer would pay due regard to this. Just let me pause there, if I may. That's exactly the same here. If the Speaker or the committee abuses her powers, those decisions will be, then the remedy is to set aside the decisions, not to declare the law invalid. Secondly, and this is really where the rubber hits the road. Secondly, the legislation must be construed consistently with the Constitution and thus, where possible, interpreted so as to exclude a construction that would be inconsistent with judicial independence. Let me pause there. The court is saying when there is a potential problem, you first seek to resolve it by means of interpretation, not by means of striking down. That's the point I made earlier. It's the first principle. It's the 39.2 point, and it applies. Then the court goes on, almost as though there were a but. But if it is to be held unconstitutional, the appropriate remedy ought, if possible, to be in the form of a notional or actual severance or reading in, so as to bring the law within acceptable constitutional standards. Only if this is not possible must a declaration of complete invalidity of the section or subsection be made. So the court's saying there, if you can't fix it by means of interpretation, and you have to strike something down, you first try severance or notional severance. You strike out the words that are the problem, or you read in words to fix the problem, to bring the law within constitutional standards. And only if this is not possible do you give a complete declaration of invalidity of the section or the subsection, not the entire statute, not the entire regs, as our learned friend seeks to do here, just the section or the subsection. And the reason with respect, Justice Bartman, is obvious. As I will come to, and I'll come back in the note to an example of how the court did that. If the court had simply struck down entire swathes of regulations about the disciplining of magistrates, then magistrates would not be disciplined, even if they committed misconduct. And so the court didn't do so. It said we've got to take a narrow surgical approach. Just as here we submit, you should dismiss the entire challenge. But if you find any one of the 12 grounds is good, you must engage in a narrow surgical remedy to fix the problem. And I'll come back to that in a moment. So that deals with the approach with respect, the approach to the merits and the approach to remedy. Can I now turn to the first substantive issue I need to deal with, and that is the role of the panel. Now, the public protector has only pleaded one ground for attacking the panel, and that ground is about the fact that a judge on the panel is impermissible because it breaches the separation of powers. Mr. Breitenbach has already argued that in detail. We've dealt with it in our heads. I'm not going to re-argue it. I stand by the submissions, and I think my submission with respect is that there is no merit to that challenge. But Justice Delamo then raises a different and important point. Justice Delamo asked our learned friend, Mr. Breitenbach, well, is it permissible for the National Assembly to have a panel at all to advise it on the question of whether there's a basis for removal? Isn't there, as I understood the question, and Justice Delamo, correct me if I'm wrong, isn't it necessary that the National Assembly do this itself, not outsource its function or have someone else do it? But we submit with great respect that while the question is undoubtedly an important one, it need not concern the bench in these proceedings for two reasons. Firstly, because it has not been pleaded. There is no attack whatsoever on the grounds that there should be no panel. The challenge instead is on the grounds that the panel should not have a judge on it. And if it's not pleaded, it's not pleaded with respect. It can't morph into a new ground for the public protector. And there is no basis for it. The whole basis for the challenge, and we've given you the reference, was that the panel mustn't have a judge on it because that breaches the separation of powers. That's the first reason, and that ought to put an end to the matter, and we've drawn your attention to the Sheikh judgment, which deals with that. But I don't want to be understood to be running away from the problem, because in the substance of Justice Delamo's concern, though understandable. Oh, and let me say, of course, I accept that there are very rare instances in which a court can raise matters mere motu, but with great respect, that would require full argument. It would require full heads. This is not a point that has been raised at all. And indeed, in the Sheikh judgment, the court makes the point that you can't have the court raising these novel and difficult issues and deciding them themselves, except in the most extraordinary circumstances. But I don't want to be understood, Justice Delamo, to be running away from the merits of the point. Let me deal with that, and that's the second reason. All the panel is doing is it's providing advice to Parliament. It is not making a binding decision on anybody. And Parliament, like all other officials and all other entities, is always entitled to seek advice, always. Parliament seeks advice all the time. It seeks advice from legal advisors, it seeks advice from counsel, it seeks advice from expert economists, it seeks advice from all sorts of people. Similarly, the president does so. Similarly, Transnet does so. All organs of state do it all the time. And that is no novel proposition. And I've pointed you to the relevant law in that regard. That's the SCA judgment in Minister of Environmental Affairs versus Cinematic. There, the SCA said the following. It said, a functionary in whom a discretionary power is vested must himself exercise that power in the absence of a right to delegate. So you can't delegate the power without a right to do so. Then there's a quotation from old authorities which say, it is well established that a discretionary power vested in one official must be exercised by that official or his lawful delegate, and that although where appropriate he may consult others and obtain their advice. Could I just underline that? Although where appropriate he may consult others and obtain their advice, he must exercise his own discretion and not abdicate it in favor of someone else. He must not, in the words of Baxter, pass the buck, act under dictation, and if he does, the decision will be unlawful and a nullity. So what that is saying in very emphatic terms, Justice Dolamo, is there's nothing wrong, even without a statute authorizing it, here the rules do authorize it, there's nothing wrong with the decision maker obtaining advice from someone, provided that he's obtaining advice and that he exercises his own mind ultimately on what to do. And of course, that's exactly what these rules contemplate. The panel's decision is not binding or determinative. The panel's decision is merely advice, and ultimately it is for the National Assembly committee, the National Assembly to decide whether to refer it to a committee, having taken account of the advice. And there's no delegation here because there's no binding decision. So I immediately accept, Justice Dolamo, that if the rules had said we delegate this power to the panel, that might give rise to a difficulty. But there's no delegation here because there is no binding decision. But let me carry on with the quote. As to the reliance on the advice of another, so again, we're talking about advice, the functionary, that's Parliament, would at least have to be aware of the grounds on which that advice was given. Let me pause again. That is why the rules say that the panel has to provide a summary of its reasons, so that when it comes to the committee, so that when it comes to the National Assembly doesn't just know Justice Nkabinde said A or B, they know why Justice Nkabinde says A or B. But it does not follow that a functionary in the DGG in this case would have to read every word of every application and may not reside on the assistance of others. Indeed, given the circumstances, Parliament could hardly have intended otherwise. What the functionary may not do, of course, is to adopt the role of a rubber stamp and so rely on the advice that it cannot be said that he or she exercised the power. If in making the decision he was simply to rely on the advice without knowing the grounds on which that advice were given, the decision would clearly not be his. But by the same token, merely because he was not acquainted with every fact, did not mean that he would fail to exercise his discretion. Whether, therefore, there's been an abdication of the discretionary power vested in a functionary is ultimately a question that must be decided on the facts of each case. So, in answer to your question, Justice Dolamo, there is nothing impermissible about Parliament, which is vested with a function by the Constitution, relying on advice, provided three things. Number one, it can't delegate that to someone else to make a binding decision, but that's not what's happened here. Number two, it must make the final decision about whether to refer to a committee, but of course it does. And thirdly, it must make that final decision knowing not just what the advice was, not just the conclusion, but it must know the reasons therefore. But here it does have those reasons because that's what the rules say. And once you understand it that way, then there's no difficulty. Of course, it's notionally possible that some National Assembly one day might not bother to read the reasons. They take a decision without looking at the reasons don't serve. Then it will fall to be set aside, just as Van Rooyen told us. But the point is, it doesn't invalidate the rules. The rules are good and lawful, only if the rules are not properly exercised that get set aside. Could I add one last point to that, which if the court would make a note, because it's not in my notes. Reference was made yesterday to the full bench judgment in Earthlife Africa. It's Earthlife Africa Cape Town versus the Director General. I'll come back to it, but the reference is 2005, volume 3 of the South African Law Reports, page 156. It's a decision of the full bench of this division. And the passage I wish to refer to for present purposes, I'll come back to other passages, is paragraph 74. And there the question was, well, if you're going to hear someone, can you get someone to hear on your behalf? In other words, if you're the DG hearing a fishing license application or whatever it is, can you get someone else to do the hearing on your behalf? And the full bench, and this is the binding authority, says, it does not follow from the paragraph 74, it does not follow from the aforegoing authorities that an interested party is invariably entitled to be heard by the decision maker personally. The weight of authority appears to indicate that some other person or body may in suitable circumstances be appointed to hear the interested party, whether orally or by receiving written representations. That procedure may be permissible where the enabling statute authorizes it, and it may be convenient course to follow, e.g. where the credibility of witnesses is not involved. So there is nothing wrong with respect, in answer to Justice Delamo's question, with the National Assembly saying, we are not going to decide for ourselves initially whether there is a prima facie case, and whether there's a case that justifies referral to a committee. We're going to hear from the expert panel. The expert panel will hear the public protector or the Commission on Gender Equality or whoever on our behalf, but we will make the decision. That's perfectly consistent with the principles in EarthLife Africa and the ones in Cinematic. So the question of the panel can be put to one side, because even if you were to look past the pleading point, even if you simply were to decide it mero motu, and I submit that would be quite an extraordinary approach given that the public protector took 12 grounds and didn't raise this one, but even if you were to do that, there is with respect no concern that arises because of the cinematic principles that I have laid out. Could I then turn to the third topic, Justice Bartman, and the third topic is retrospectivity. Now, the public protector's argument yesterday, as I understood it, was not that it was impermissible inherently for the rules to apply to conduct that took place before the rules came into place. I understood the argument differently. The argument was, if the rules were to apply retrospectively, they had to say so expressly. And so the argument went, you see, that's why the DA has now come up with a new motion in order to avoid the retrospectivity problem. Now, with great respect, that's a point made by my learned friend on his feet. It ought to have been pleaded, but let me tell you that it's without any merit whatsoever. The DA motion, if that were the case, would not have referred to all of the old things that happened. But that's not the reason for the second motion. The reason for the second motion, as is apparent when you compare the two motions, is it wanted to ensure that all of the relevant evidence and materials were before Parliament. You didn't want unnecessary technical debates around all of this. It had nothing to do with retrospectivity. But let me leave that aside, because that, with respect, is a real debating point, and it's a poor debating point because it doesn't go to the heart of the question. The real question is, if the rules are to apply retrospectively, does there have to be an express provision in the rules saying that? Or can one infer or conclude that they apply retrospectively without that? And our learned friend says, no, if there's no express provision, then they can't apply retrospectively. But with great respect, Justice Bartman, members of the bench, that is not our law. On the contrary, as our point I make in paragraph 15, the proper approach is to look at the law, whether it's a statute or a set of rules, and to see whether it was intended to apply retrospectively. And this can be because it says so expressly, or it can be by implication. And that's made clear by the very Leck decision, which my learned friend, Mr. Breitenbach, referred to, in the heads. There, what this court said was, it's about whether you can draw an inference that it was due to be applied retrospectively, and such an inference can be drawn when the consequence of holding an act to be non-retrospective would lead to an absurdity or practical injustice. Now, that might be a decision of this court a number of years ago, but the same principle has been adopted by the Constitutional Court. And in paragraph 16, I refer to the Electoral Commission versus Mhlophe case. There, Justice Madlanga dealt with the same presumption, and he said, the presumption against retrospectivity is rebuttable. It is not a magic wand that must trump a discernible purpose of a legislative instrument. So again, making clear, it's not about whether there is a section which says this shall apply to events prior to commencement. You read this, you do what courts do all the time. You start with a presumption that it doesn't apply retrospectively. Then you read the act or the rules or whatever it is, you seek to discern the intent and the effect. And if you discern the intent and effect is to apply retrospectively, then that's good enough. Doesn't matter whether there's a specific provision. Now, the only authority our learned friend offered in opposition to this was a dictum from the old 1910 decision of Curtis versus Johannesburg Municipality, endorsed in the Pienaar Brothers case. Pienaar Brothers was a tax case in which what SARS had done, I was fortunate enough to be in the case, although I know very little about tax, but Pienaar Brothers, what had happened was SARS had, the Minister of Parliament had amended a statute. It used to be able to claim a deduction, and now you couldn't claim a deduction, and they made it retrospective, and they said so expressly. So this wasn't even an issue there, let me say. But in Pienaar Brothers, what the court did was it quoted Curtis as saying, in the absence of express reference, statutes should, if possible, be interpreted not to take away rights actually vested at the time of their promulgation. Well, you can understand that with respect. If I've been calculating my tax on the basis of a deduction, and in a month's time a piece of legislation comes in, you won't likely assume that my right to claim the deduction has been removed unless there's an express provision to that effect. You can understand that. But that's got no bearing here, because there are no vested rights that have been taken away. The public protector didn't have a vested right to avoid removal. She didn't have a vested right to avoid having to account to the National Assembly. She didn't have a vested right to engage in what the Constitutional Court called dishonest conduct. So there's no vested rights here. And so with respect, the line is not helpful. The bottom line, Justice Bartman, members of the bench, is that this court is faced with two interpretations of the rules. The first interpretation that is urged by the public protector means that everything that took place before these rules is beyond Parliament's reach. They can't look at the fact that the Constitutional Court held that she acted in bad faith and in a grossly unreasonable manner, that she was not honest, and that her conduct falls far short of the high standards required by her office. Parliament, on their interpretation, cannot look at the fact that her conduct was held to be far worse in the Freda Dairy case and more lamentable than that set out in the Reserve Bank matter, and that her conduct during the entire investigation constitutes gross negligence. They say that this court must give an interpretation to the rules which says Parliament is unable to deal with that. The alternative interpretation is the one that the Speaker advances and that we advance, which is to say, of course, Parliament can look at it. She is entitled to the procedural protection of the rules. She is entitled to a right to defend herself. And Parliament is entitled to do what it is meant to do, which is to look at whether to remove her. Now, which of those two interpretations, I ask rhetorically, Justice Bartman, better promotes accountability, responsiveness, and openness, the three values that appear in Section 1D of the Constitution? With respect, it's self-evidently the second interpretation, because anything else would prevent what the Concourt has called the ultimate accountability mechanism being used at all. So the Concourt called removal, in the UDM case, the Concourt said removal was the ultimately accountability mechanism. Yet the public protector's argument is she wants to be immune from that ultimate accountability mechanism completely for any conduct that occurred before the rules came into force. No matter how egregious, no matter how glaring, with great respect, that cannot be a proper interpretation of the rules, and it cannot be an interpretation that this court would easily adopt. And there's no basis or need for it. It makes perfect sense. And it's true that my learned friend, Mr. Mpofu, says that the line between procedure and substance is sometimes blurred. But these fundamentally are rules which are about process, because we know what the grounds of removal are. The grounds of removal are those that are set out in the Constitution. These are just giving flesh to the bone and the process. And it makes perfect sense that it would apply both retrospectively and prospectively. So the retrospectivity argument with respect has no merit. That then leads me to the next point, if I may. And that is the question of legal representation. Now, you will have seen in our main heads of argument that we explained in paragraphs 47 to 54 why the legal representation complaint is not well-founded. And we did so on the basis of various authorities which make clear that our courts have consistently denied any entitlement to legal representation as of right in fora other than courts of law. But you've heard that argument with respect from our learned friend, Mr. Breitenbach. You've read our argument in our heads, and I don't want to belabor the point. We say it's right, but I don't want to belabor it. Could I just assume for a moment that I'm wrong? Could I assume that this court concludes that the Constitution demands, I must be honest, it's not clear to me on what basis, but that this court concludes that the Constitution demands that the public protector have legal representation in the committee, actively in the committee. Let me assume that against myself. The question is, what then? Our learned friend, Mr. Mpofu, argues that that means the entire rules must be struck down. In other words, because of this one defect, the absence of legal representation, you chuck the baby out with the bathwater, and the public protector, instead of getting a right to legal representation, which you would think would be the remedy, is immune because the rules get chucked out and the EFF judgment means she can't be impeached. Just, if I could just say that again, the argument is because the rules don't give her a right to legal representation, the consequence is not give her the legal rep. The consequence is chuck the rules out in their entirety. She can't be prosecuted. She can't be removed at all. With great respect, there is no basis for that in the Concourt's jurisprudence. And that's demonstrated by the Van Rooyen case I referred to earlier. So we say that if there is a constitutional problem around legal representation, there are two ways of solving it for this court. The first and preferable route is to solve it, as Van Rooyen told us, via a process of interpretation. Because what Rule 129AD2 says is that the committee must ensure that the inquiry is conducted in a reasonable, procedurally fair manner within a reasonable time frame. Rule 129AD3 then says that the committee must afford the holder the right to be heard in his or her defense and to be assisted by a legal practitioner or expert, provided that the legal practitioner or expert may not participate in the committee. Now, there are two ways of understanding it. One is the way the speaker understands it, which is to say, that means your lawyer may not speak in the committee. The other is the way that we postulate in paragraph 52 of our heads, which says it means you have to speak for yourself, you have to account for yourself, but that doesn't preclude you using the lawyer for legal purposes like cross-examination. Now, if you interpret it in that way, you solve the problem, because what you do is you say, you're giving adherence to the speaker's point that a legal representative can't speak for Ms. Mkhwebane when she is asked questions. But you are dealing with Justice Bartman's concern, quite understandably, that there might need to be someone who cross-examines better than the public protector does, or better than Mr. Breitenbach does, or better than I do. And so you've solved the problem by giving the best possible interpretation of this, and one that gives effect to what the speaker says is the real concern. If you interpret it in that way, then you've solved the problem. There's no need to declare it invalid, and you've protected Ms. Mkhwebane's right to legal representation on the assumption that it exists. So that's the point we make at paragraph 22.1 through to 22.7. And let me say, of course, this court's decision on how to interpret it would be binding on the committee. And so, assuming there's no appeal, that would mean is when the committee meets, the committee will have before it this court's judgment, it will be binding and it will have to follow it. You don't need to strike it down because it will be bound by this court's interpretation of the committee. So if there is a problem, that's the way to solve it. Let's assume, however, that this court concludes that it can't solve that problem in that way. That takes us to the second way of solving it, which is paragraph 23. 23 says that if this court concludes that the interpretation is not tenable, the words do not give rise to that, they're not sufficiently flexible for that, then that doesn't mean that the public protector gets off scot-free, that all of the rules are struck down and that she doesn't have to answer for her conduct, and that the Concourt's concerns disappear into the ether. The way to do it is an order of severance. Now, my learned friend, Mr. Breitenbach, spoke about severance, but with respect, he didn't explain it. I know he was under considerable time pressure, but he didn't explain it in detail. Severance literally means striking out the words that cause the problem. So you strike out the problem, and the words that cause the problem, if there is a problem at all, the words that cause a problem are provided that the legal practitioner or other expert may not participate in the committee. So you'll recall that what the clause says is it says the committee must afford the holder of a public office the right to be heard, no problem with that, in his or her own defense, no problem with that, and to be assisted by a legal practitioner or other expert of his or her choice. No problem up to that point. But then comes the problem, as our learned friend characterizes it, comma, provided that the legal practitioner or other expert may not participate in the committee. So what is the solution, Justice Bartman, if there is a problem here? You strike down the provisor. not the whole of the regs, not the whole even of the section, just the proviso. And that solves the problem. Because what that would mean is that Rule 129 AD3 would read, as I've reproduced it at 23.2 of my note. It would now read, the committee must afford the holder of the public office the right to be heard in his or her own defense and to be assisted by a legal practitioner or other expert of his or her choice, full stop. And that cannot give rise to any problem whatsoever on any basis. So we say that that would be the appropriate remedy if the court were against us on the legal representation point. And we say that you know that that is the appropriate order because that is what the Con Court did again and again in Van Rooyen. I have already referred you to paragraph 88 of Van Rooyen. I now give you a series of more references because what happened in 88 was that the court explained the principled approach, and then it went through all of the provisions that Justice Southwood had struck down left, right, and centre, and it explained how to fix them. And I'm just going to give you one example. We quote at 23.4 that what said there, this is the unanimous constitutional court, it was dealing with a regulation that allowed for the removal of magistrates in a way that it was held not to be consistent with judicial independence. And the question was, do you strike down the whole thing or do you just fix it up? And here's what the court said. If Regulation 2617 is declared to be invalid and the presiding officer at any inquiry is a magistrate, that was the issue about whether there should be a presiding officer as magistrate, the remainder of the regulation will serve the legitimate and important purpose of providing a framework for conducting inquiries into serious allegations that might warrant the removal of a magistrate from office. The appropriate order, therefore, is not to declare the whole regulation to be inconsistent with the Constitution, but to sever the offending portions from the regulation. The order of the High Court declaring the whole of Regulation 26 invalid is set aside and is replaced with an order deleting the words "or person," where they appear for the first time in Regulation 26(6), immediately before the words "herein called the presiding officer," and deleting the whole of Regulation 2617. Now, Justice Bartman, that demonstrates the fallacy of our learned friend's approach. He is asking this court to do exactly what the Con Court castigated Justice Southwood for doing. Justice Southwood had declared the whole of Regulation 26 invalid. You see that in the second paragraph. The Con Court said you don't declare the whole thing invalid. You declare the words "or person" invalid in 26(6), and you declare the words "hereinafter called the presiding officer" in 2617, and then you solve the problem. And we say that exactly the same is true here. If I could reread the first paragraph, paraphrased. If Rule 129 AD 2 or 3 is declared invalid to the extent that it precludes legal representation, the remainder of the regulation will serve the legitimate and important purpose of providing a framework for conducting inquiries into serious allegations that might warrant the removal of the public protector from office. It is utterly on point. And that would solve the problem. You would have vindicated the public protector's right to legal representation, but you would also have ensured that Parliament can carry on and that the process is not stymied. Now, all of this, of course, assumes that I'm wrong on my legal representation point and that there is a problem. We say there is none. But if you assume I'm wrong, that is the way with respect that the Constitutional Court solved it in Van Rooyen. That is the way with respect that you would have to solve it in this case. And in doing so, you would balance the interests and ensure that the remedy fits the problem. Legal representation is provided. That then leads me to the very last point, the last substantive point that I need to deal with, and that's the question of fairness. Now, the complaint here, as we understand it, is that the Speaker's decision to accept that the motion was in order, which was the decision, falls to be reviewed and set aside because the Speaker didn't hear from the public protector before she made that decision. We say that point is a bad one, but let me explain why, because it needs to be done quite carefully, otherwise one gets lost with respect. And it was my learned friend, Mr. Mpofu's submissions on this were somewhat unmoored from the principles that apply. So let's start at the first proposition. 24, it's clear that the rules allow the public protector 2 opportunities to be heard in full. She has a chance to make submissions to the panel, in terms of 129X1C1. And if the matter ultimately goes to the National Assembly Committee, if it doesn't, of course, then the whole thing is over. If it ultimately goes to the National Assembly Committee, she has a chance to make submissions, to cross-examine, to do whatever in terms of 129AD2. So she has not one, but two opportunities to make submissions. The question is not could the rules have made provision for a third opportunity. Of course they could. They could have made provision for 10 opportunities. So it's not could the rules have done a third opportunity. It's whether the rules are constitutionally invalid because they only give her 2 chances to make representations, not 3. That's what my learned friend has to persuade you of, is that the only way that this process is valid is if she gets 3 opportunities to make her submissions, not 2. Now, with great respect, that contention is just unsustainable, and it's unsustainable for 3 reasons. The first is that it's not clear where this right to be heard by the speaker comes from, because it can't come from Paja, because Paja doesn't apply. So we can put Paja to one side. And that's why our learned friend spent so long trying to convince you about Albert. He said Albert applies because it comes from the principle of procedural rationality. And I readily accept that Albert does speak about the principle of procedural rationality outside of Paja. No argument on that. But Albert does not and has never been held to confer a general right to make submissions when you're affected by a decision. Never. And I'm going to take you to the SCA authority, which says that. Albert says there is no such general right. All you are entitled to is a procedurally rational process. And so what you have to be persuaded by, my learned friend, is that it is procedurally irrational to only give the public protector 2 opportunities to be heard instead of 3. Now, there is no authority in support of that proposition. I'm going to come to the authorities my learned friend quoted, which are not for him. But there is no authority for that proposition. And in fact, in an SCA case, the court rejected exactly that kind of an argument, and I should know because I lost. It was the case that I quote at paragraph 27.2. It's the case called Kubukeli, National Treasury versus Kubukeli. What happened in Kubukeli was that Mr. Kubukeli was an official of the mayoral office, and National Treasury had investigated unlawful conduct in the supply chain management policy of the Premier's office or the mayoral office. And they produced a report, and the report said amongst the people who are guilty of the misconduct are Mr. Kubukeli and others. And in doing so, they didn't hear from Mr. Kubukeli. So Mr. Kubukeli took National Treasury off to court, and he said, I know this isn't admin action, but legality applies, Albert applies, Scalabrini applies, and procedural rationality entitled me to be heard. Exactly the same argument that's advanced here. And I argued that, and I thought that I had a point. But I was held to be wrong by the SCA and then by the Constitutional Court, which refused leave to appeal. And the reason that the SCA gave is worth studying, and I've quoted it for you. The SCA starts by saying, there is no general duty on decision makers to consult interested parties for decisions to be rational under the rule of law. Let me pause there. There is no general duty to consult interested parties for a decision to be rational. And then it cites Scalabrini, which in turn cites Albert. But there are circumstances in which rational decision making requires consultation with interested parties. So everything turns on the facts. And then the question was, okay, that's the principle, fine. The question was, well, was Mr. Kubukeli entitled to a hearing before National Treasury made scathing findings about him? And here is the ratio, binding on this court. Unlike the decisions in Albert and Scalabrini, the National Treasury made no final or binding decision. The municipality was not under any obligation to accept any of the recommendations. So they didn't just find that he was guilty of financial misconduct. They recommended that money be obtained back from him. The court says there's no final or binding decision. The municipality was under no obligation to accept any of the recommendations. Although some loose language may have been used in this regard, it is clear in the context of the report that that was said about Mr. Kubukeli and other officials was in the nature of prima facie findings. That's important because remember that all the speaker is doing she's not even making a prima facie finding. She's just saying the motion is in order. She's certainly not making a final finding. These findings are clearly not binding on Mr. Kubukeli and could be challenged in any subsequent proceedings. Paragraph 7.16.4 of the report must be seen in this light, namely that in the absence of an explanation by Mr. Kubukeli, the Treasury team found no record to account for the amount of 8,000 Rand advanced to Mr. Kubukeli. Most importantly, and here's the crux, objectively, it was beyond doubt that if the recommendations in respect of disciplinary proceedings or the recovery of losses were to be implemented, the implementation would take place in terms of processes that would afford Mr. Kubukeli a full opportunity to present his case. In other words, if the Treasury report led to disciplinary proceedings against Mr. Kubukeli as an employee, he would have his rights under the Labour Relations Act. If the Treasury report led to civil claims against Mr. Kubukeli, he would have his rights under the uniform rules and the right to file answering affidavit. Whatever happened, says the SCA, if the recommendations in respect of disciplinary proceedings or the recovery of losses were to be implemented, the implementation would take place in terms of a process that would afford Mr. Kubukeli a full opportunity to present his case. Exactly the same here. If the Speaker certifying that something is in order leads to proper proceedings against the Public Protector or the Commission on Gender Equality or whatever, the Public Protector will be afforded a full opportunity to present her case. How do we know that? We know that because that's what 129 AD2 says, and we know that that's in addition to 129X 1C1. So it is exactly the same, except that Mr. Kubukeli would only get one shot to be heard. This Public Protector will get two. And the court then concludes, I therefore conclude that the investigation report and recommendations of the National Treasury without the participation of Mr. Kubukeli were founded on reason and were not arbitrary or irrational. It follows that the appeal must succeed. So again, it goes back to where I started, Justice Bartman. It's true that this court, if it was designing the system, might have said, let's give them three chances to be heard because it might short-circuit it and more hearings are good than fewer hearings. That's not the test. The question is it rational? Is it founded on reason? And Kubukeli says, if you're only going to get heard once instead of twice, that's rational. In this case, you're going to get heard twice instead of three times. It's doubly rational with respect. So that's the first reason that this Audi point is no good, because it can't derive from anywhere. It can't derive from Paja because it doesn't apply, and it can't derive from procedural rationality because Kubukeli says procedural rationality doesn't cover such an entitlement. Second, and I'm now at paragraph 28, we come to the problem, which is the series of cases bang on point, which say that you don't have a right to a hearing before a hearing, because that's really what's being argued. Everybody accepts that the Public Protector will get a hearing under 129 AD2 in front of the committee. Everyone accepts that there'll actually be another hearing under 129X 1C1. But the Public Protector says, no, I want a right to a hearing before those hearings. And the courts have again and again and again rejected those very arguments. And we pointed you to those authorities in detail in our main heads of argument at paragraph 40.1 to 40.7. I'm not going to read all of them to you. I will only read you one, which we've quoted there. But before I do, let me say this. Those are in our heads. They were not answered by my learned friend at all. And they are the authorities that are on point. So in Langa versus Floppe, and it's quite ironic, because in that case, that is the very example that my learned friend gives. He says, well, what about the JSC? You get multiple hearings there. But let's see what the SCA held in that case. It said, while a judge is obviously entitled to be heard in the course of the investigation of a complaint, as appears from the various cases and protocols referred to by the High Court and referred to in the heads, that is not what we are concerned with. We are concerned instead with the act that initiates such an inquiry, the trigger, which is the decision to lay a complaint. In that respect, there is no authority to which we were referred or which we are aware, whether in decided cases or judicial protocols anywhere in the world, that obliges a complainant to invite a judge to be heard before laying the complaint. That's a trigger mechanism. You don't have the right to be heard before the trigger mechanism. You have a right to be heard after the trigger mechanism at the hearing. Similarly here, where the speaker concludes that a motion is in order, that is just a different kind of trigger mechanism. It is not a determination of guilt. It is not a determination, it's not even a recommendation, and it's certainly not a binding finding. It is just a conclusion that a motion is in order. And it's not just that case. Viking Pony Africa in the Concord, Competition Commission versus Yarra in the SCA, old cases, Mayer versus the Law Society in the TPD, Wiseman versus Bornman in the House of Lords, Morn versus Lloyds in the Court of Appeal. All of those cases are consistent. There is no right to a hearing before hearing. And if my learned friend cannot explain to you why those cases are wrong, then with respect, that is the binding authority on this court. Thirdly, and the third problem is, let's go to what my learned friend put before you as the authorities. He relied on two authorities for this right to a hearing. The first was the NERSA case, and the second was the EarthLife Africa case. But neither of those establishes what he needs. NERSA was not a case about procedural rationality at all. NERSA was a case about a failure to take into account relevant considerations. Now, what had happened in NERSA was the setting of a gas price. And I've quoted for you paragraphs 64 and 65. Our learned friend, Mr. Mpofu, relies on 64. That is the passage he quoted in his heads and he quoted in oral argument. And what it says is, rationality is concerned with one reason question, do the means justify the ends? Democratic Alliance developed the test for rationality by explaining that an absence of a sufficient link can arise for procedural reasons. This is not a new or different type of irrationality, but rather a way of evincing a broken or missing link between the means and the end. The means chosen by an administrator include everything done or not done in the process of making that decision. Okay, but now read it with the next paragraph that follows in the judgment. In this case, NERSA failed to consider Sasol's marginal costs in the method it used to determine the maximum gas price for Sasol. The decision to apply the basket of alternatives approach specifically to Sasol was not rational. Sasol is a monopolist, and any rational attempt at regulating its prices needed to consider its costs in order to fairly and equitably divide up the economic surplus between Sasol's profit and the economic value for Sasol's consumers. It had nothing to do, that passage, with whether you had a right to a hearing before hearing. It was about where you are bound by the principle of legality, do you have to consider relevant considerations? And the answer was yes. It's got nothing to do with this case. Then we come to EarthLife. EarthLife was the decision, I've actually referred to it earlier. EarthLife was the decision of the full bench about certain environmental approvals. Before I forget, I have given you references to paragraphs in that quote, just under 29.2, the very last point. Those paragraph references are wrong. I was working off Safley and it is inaccurate. Can I please give you the correct ones? Can you cross out 53 to 54 and 73? And can you please write in 35 and 49 to 50? I don't know how Safley and Juta got it so wrong, but it's 35 and 49 to 50. Now what happened in EarthLife was that there were debates about whether it was a DG's decision about granting environmental approvals. The DG was the decision maker. He had to decide whether to grant environmental approvals. But his decision was subject to appeal to the minister. So what happened was that the DG made certain decisions, and he did hear from EarthLife, but EarthLife said that they didn't hear adequately. They weren't heard adequately because of various reasons, which I'd like to read to you from the judgment very briefly. But the critical point is that everyone was agreed that there was a right to be heard before the DG, because the DG was not making a recommendation, the DG was making the decision. He had the statutory power to make the decision. And so at paragraph 49 of the judgment, the court said, in the context of the present case, the parties were ad idem that the applicant was entitled as part of its right to procedural fairness to a fair hearing before the decision was made by the DG. So the court was not debating whether there should be a fair hearing, it was common cause. And then the court said it was further common cause that the right to hearing did not extend to an oral hearing, etc., etc. Where the parties differed was whether or not, on the facts of this case, the applicant did indeed enjoy a fair hearing. The respondents maintained that the applicant had been afforded an adequate opportunity to make written representation during the public process, And then the applicant said, while it conceded that there'd been a public process, it lacked the following problems. There was not access to information, there wasn't a proper opportunity, etc., etc. So that case is not at all about the question of whether one is entitled to a hearing before a hearing, because the decision maker was the DG, and it followed ineluctably that you had a right to a hearing before the DG, and everyone agreed that you had a right towards the DG. The only question that could peripherally be misunderstood as applying is what appears at paragraph 35, because the suggestion was made, if you give me a moment, the suggestion was made that 34 to 35, that, well, because there are still going to be appeals, you shouldn't come and review now. You must come and review at the end of the day. It was a prematurity argument. And the court rejected that prematurity argument because it said the fact that it might be subject to another decision at the end of the day doesn't mean that you can't come and review now. That's the only potential relevance. It said you had a right to Audi. If your right to Audi was breached, which of course was what everyone was, let me go back a stage. Everyone was common cause that you had a right to Audi at that stage. The debate was whether it was breached. And the court said, don't come and tell me that you might have an appeal and therefore you can't come and review now. You can review now because you had a right to Audi. If that was breached, that was it. And that's all Earthlife says. So the only two cases that our learned friend puts up, with great respect, are just simply not authority for the proposition. And against that are the series of cases that I have given you: Kubukeli, Lange, Viking Pony, Competition Commission, Mayer, Wiseman, and Moran. And so with respect, there is no right to a hearing before a hearing. There is certainly no right to a hearing before two more hearings. And that is the argument that has to be advanced. Justice Bartman, those concludes my substantive submissions and the submissions on the, read together with my heads. There's only one last point to make. It is the question of costs. Now, you've heard a great deal about costs from my learned friends, both Mr. Mpofu and Mr. Breitenbach. I'm not going to adopt the same approach. We have asked for punitive costs, and we've asked for it on the basis of what is set out in paragraphs 98 to 109. But there's a reason I'm not going to argue it, even though there's half an hour left, is that actually this case is more important than costs.
No, 15 minutes. The extra 15 minutes is not for you.
I'm so sorry, my lady. I didn't hear that at all.
Not your. You could use it.
I'm terribly sorry, my lady. I'm struggling to hear you. Could I ask you to say that again? I do apologize.
No, otherwise it's 16 minutes. No, it's fine.
If I understood your ladyship's tone and face, it was a facetious remark, not facetious, it was a jovial remark that I should make use of the time. Now, I do understand. But my lady, well, the point I wanted to make was this. There are fundamental issues of constitutional democracy involved here. We have a public protector who has been subject to the most searing criticism of any public official that I can remember in the history of our constitutional democracy. Parliament is trying to hold a process to determine whether she should be removed. That is what is important, to ensure that that process can continue and ensure that it happens within constitutional bounds if there's a problem. In that scheme of things, the question of costs should recede into the background. And I am not going to waste this court's time by talking about costs, even though I do say that what is said about the DA by the public protector is wholly inappropriate, as I've explained. But with great respect, this case is about fundamentally more important things than costs. And it's about ensuring that whatever this court does upholds accountability, responsiveness, and openness as the Constitution requires. And with great respect, the arguments and the remedy that is sought by the public protector are at odds with that. And you have to ask yourself, with respect, you have to ask, why is it that the public protector is trying to chuck the baby out with the bathwater? Why is it that she doesn't want the same severance approach applied in every constitutional case for the last 20 years? Why is it? And the reason is because she is trying to avoid the constitutional proceedings, the removal proceedings carrying on. And that, with respect, is not what constitutional justice entails. It is not what accountability entails. And so if you do find there's a problem, and we hope you won't, if you do find there's a problem, I urge you with respect to fix the problem by interpretation or severance and allow the process to carry on, because it would fatally undermine our constitutional scheme. For someone who has had these things said about them to be able to say, well, I'm not going to go to removal proceedings. Why? Because of some technicality or some problem here or there. It is simply untenable that a constitutional organ, a Chapter 9 institution, should be seeking to have this court provide such a solution. Justices, I am indebted, and those are my submissions. If, of course, there are any questions, I'd be happy to take them if I can hear you. But those are my submissions for the moment.
Mr. Buckland, I hope you can hear me. There are no further questions from the bench. Thank you.
Thank you very much, my lady.
Tomorrow is between you and the amici.
That's correct, my lady.
And you talk time with the amici.
No, my lady, but I can arrange so that by the time we come in the morning, I will have spoken to Madam.
Try to arrange so that you might half an hour extra over the lunch.
Yes, well, if we.
Remember, it's reply.
It's.
Reply.
Yes, my lady. No, I remember. I will remember. My lady, yes, no, that's quite happy, my lady. We would have, actually, unfortunately, our land friends did not, as they say, play ball. Yes, we had a whole lot of arguments. The amici, according to our plan, would have started today, but it's fine that we can start tomorrow. I'm sure from what I've seen of the amici submissions, I don't think they will be long. I will certainly, after this performance of today, I won't be that long myself. That's fine.
Please laugh. This court is declared unconstitutional.
Come and take all of these things. Almost in 4 minutes. Let's you talk tomorrow. Must come and take stuff.
People looking like yesterday, get a little box with the deleted.
Must use it again?
I'm not going to be here tomorrow.
I think maybe I'll be tomorrow in our anyway.
You get joined.
Jennifer, I'm going to video question you. This chair is really a searcher. I did not USB pin. I saw that USB pin.